Lordship, one IA has been filed in BA number 6463 of the 2026, Your Lordship, for provisional bail, Your Lordship, as the brother of the petitioner, Your Lordship, had died, Your Lordship.
So there is one matter related with scene number 13 is regarding fixation of pension as per the last admissible pay. As it is now settled by the Honorable Supreme Court, tested before the LP Court and even Supreme Court, it has been announced. So I'm just praying that if I consider it part, then it will be disposed. Scene number 39. I'll inform the others if any date.
I had mentioned on case yesterday listed today. In the report number 14 is not available today. The only thing that it will be heard by this bench only today is the last date for filling out the application. I had informed the council for the other side, he has given consent.
That's right, but it is there may be many other candidates are similar. How do I commit this?
Let's say if I am playing for interim leave with respect to myself.
That's right, but the point is in a recruitment process, there are so many identical persons who are at par with you. Then how do I justify an isolated order like this? Okay, you just get all of the file, but I'm not inclined. I'm telling you, I've disclosed my mind. But in a recruitment process like this, it is not possible.
I can understand, but they are not
You
vigilant.
can understand.
They are not vigilant. Ladies, if I am vigilant, I have come before some people.
They are not. You see, it is entirely a matter of policy and administrative decision as to what relaxation they will give, what relaxation they will not give. It is not within the domain of the court to give such a relaxation.
But it is interpreted by the mentioned the matter of civil justice.
That was a different situation.
I think my situation is on better footing. Anyways, it may be taken up today.
You call the other side. Unless they are there, we cannot do it.
If any time may dispute, I will ask them to come and interpret it. Much appreciated.
Not, yeah, just come at 1 o'clock. Because you have to fill the form now.
Charge sheet is filed in different section. Earlier, the fire was registered in 366A and charge sheet has been filed in Fox. So, therefore, I will be permitted to withdraw this application because
Which application?
Bail application.
Which one? You have to file your the bill application is pending listed today. What is the situation?
It is in defect.
It is in defect.
From the supplementary list under heading for orders, item 1 BS 6/08 of 2026, filing number.
As per the office, there are 3 defects, out of which 2 have been removed. For one, we have filed an IA for including that defect. Now that is IA number 9312.
You should take care that nobody should from your office should contact the courtmaster post court hours for listing of this. Henceforth, any mention सुन रहे हो? जिसको भी mention करना है, आपको slip देना. 10:30 बजे के बाद किसी का slip accept मत करिए. हम कोर्ट में बैठे, और चाहे ना बैठे. Right? This is for the notice of everybody. If you have to give any slip, you have to give before then. Right? Since it was yesterday, and yesterday was the last day, I have extended the time for you. So you delete election 3.
Yes.
Filing number BA 6808 of 2026. IA number 9312 of 2026 has been filed for ignoring defect in connection with election 3. Election 3 is effectively a truncated document. The learned counsel for the petitioner submits that the other portion of election 3 is not available. Considering the interrogatory application, any truncated document cannot be considered. In such circumstances, the learned counsel for the petitioner seeks permission and is permitted to delete election 3 in writing from the records of this case. It can be done during the course of the day. I will dispose of office is directed to place this case and application. There is no other.
No other. We have already filed a supplementary affidavit with regard to the earlier move paragraph. And
there is one more defect that the Parvika is the relative of the victim. So the affidavit has to be filed in a redacted copy. We have already filed the redacted copy of the affidavit.
The council submission, the remaining defects have already been done. The review order is dated 15/20. Was this case on Saturday?
Under heading for admission, item 2, DA.14.07.2026.
Let us say in the last occasion, this is directly to file the counter affidavit with 8 minutes, and already 5 minutes for the case of cybercrime. And this case,
This case arises out of labor.
yes, miss. And this is a recovery of
Just, we are on that. We want to put in a photo of your affidavit.
Yes.
I can understand so far as other states are concerned.
You already here made the statement that विरुद्ध इस कांड के अलावा अन्य कांड राज्य और राज्य से बाहर दर्ज नहीं है. He had already given the criminal antecedent report. That page 4 annexure A of supplementary.
Annexure 4 में आप देखिए नहीं तो धनबाद वाला जो केस है इसका कोई एफआईआर रजिस्टर नहीं हुआ है. There is one case in Dhanbad. Do you want to say that no case has been registered in Dhanbad?
ये ऑलरेडी हमको जो रिपोर्ट दी हम रिपोर्ट
हम भी रिपोर्ट
हम उनसे कितनी बार डिस्कशन कर चुके
कोई बात नहीं हम एसपी धनबाद को बोलते हैं ये नंबर 3378/2026 a supplementary affidavit has been filed before this court on behalf of the state for scrutiny order dated 8/6/2026. For the revision of supplementary affidavit, the council for the state has submitted that as per the report, apart from the present case, no case has been instituted in the state of Jharkhand or any other state. The report indicates that there is one acknowledgement at serial number 2, whose number and details have been mentioned, which has been found from Dhanbad. The Lawyer Council for the state is directed to seek instructions from the Superintendent of Police Dhanbad and file an affidavit as to whether any FIR has been instituted in connection with the acknowledgement and the details mentioned therein. It will be done within a week. Get a copy of this order along with a copy of order dated 8/6/2024 and supplementary counter affidavit of the opposite party state with its enclosure in PA number 3378/2026 be forwarded to the SP Dhanbad office.
ये
The affidavit should be filed by next week. So आपको affidavit file करना है लेकिन उनको communicate हम कर देंगे. And if that be so, then I will take that all other FIRs are not being instituted. एक sample तो देखिए आपकी state का. Let us find out if there is an acknowledgement and no FIR is being instituted. So we will take it that no FIR is being instituted in other states also.
एक्चुअली बहुत सारे केस में जो हम लोग लिख रहे हैं कि क्राइम लिंक से वेरीफाई करके आप क्रिमिनल एंटीसीडेंट रिपोर्ट हमको बनाइए. After several letter discussion,
अभी आ जाएगा धनबाद से information.
जब तक एक दो नहीं आएगा हमारे पास वही घिसा पिटा वो क्रिमिनल रिपोर्ट का जो 4 लाइन का जो आ रहा है उतना लिखने के बाद भी वही चीज आ रहा है.
नहीं आ रहा ना तो इसलिए बाकी स्टेट्स के बारे में हम लोग बाद में सोचेंगे. एक चीज और लिखिए. The supplementary affidavit to be filed by the SP Dhanbad should also indicate as to what is the modality and any FIR is to be instituted on the basis of such crime report being reported at Dhanbad. देखते हैं. Next state would be 27. The affidavit should be filed by 20.
Item 3 DA.14.07 of 2026.
काउंटर का डायरेक्शन काउंटर रेडी है
But in this case, there is recovery of two mobile, one SIM. There is no criminal antecedent I have stated. There is one victim of 5,000. 5,000 charge sheet has been submitted.
Just a moment. 2 mobile, 1 SIM, and
And no antecedent.
1 victim.
One victim of 5,000 that has come.
No antecedent.
No antecedent. 99 specific.
सॉरी
इसमें तो फाइल दूसरे का ऑलरेडी काउंटर फाइल है इसमें भी
दूसरे का
कहीं पर कोई केस नहीं although there are 37 crime link हैं मगर कोई FIR नहीं
एसपी से एक्सप्लेनेशन मांगा गया था
इसमें झारखंड में भी 27 कंप्लेंट्स हैं. Total crime link is 29.
37
37
झारखंड
नहीं टोटल 37
में आप क्या नाम है petitioner?
अनूप
एक
कुमार
सिंगल एक्यूज है इस केस में.
अनूप कुमार दास
Is there a Vicky? Paragraph 3. Paragraph 3 है ना?
Yes.
There is a chart.
Yes. Jharkhand is at serial number 15. Yes.
There are altogether
NCRP made 2 complaint. NCRP 27 complaint. Total complaint 29.
20. Do you want to say that there is no FIR instituted?
ऑलरेडी एसपी का रिपोर्ट एसपी का जो रिपोर्ट है एसपी उसको वेरीफाई करके रिपोर्ट लगाया हुआ है और पूरा डिटेल्स उसको बना के दिए हुए
May I clarify one more thing, if your lordship may allow. The one more case, my lord, in which your lordship has called for the case diary, in which the petitioner was apprehended at Devghar, my lord, and there was a complaint on IML portal, and after his arrest, my lord, after 2 years, when the Latehar, there was a complaint, my lord, on NCRP portal. After 2.5 years, the complainant had lost the FIR and took the money. After 2.5 years, when she came to know about this portal, when police she lost the FIR. See,
स्पेसिफिक एसपी साहब का जो है
after 2.5 years, when she came to knowledge of the
She took the money.
yeah,
From whom?
business, they are taking money
No, just
settlement.
if there is a crime report
Yeah.
for fraud of rupees 5,000 by 1 victim, this crime report is being utilized for the purposes of giving the money to the victim if it could be trapped in any accounts. That is being done, and that is why these are being reported and
Yes.
acknowledgement number is there,
Yes.
and ultimately the victim takes the money.
Takes
Then the victim is not interested because the victim has got that money. But the crime stands proved.
unless
Isn't
she come and yes, she comes to report.
And there is no such step that if a person is acquitted in such a case, then
for recovery of the
then how this money is to be recovered
money
from
is to
her?
be yes, there is no such step.
There is no such step.
Lord, there are so many methods.
And you just see this para number 34.
Yes, that I have seen. Lord,
Yes.
taking into consideration this, Lord, your last occasion, your leadership has passed the order, and after that, this affidavit has come. I mean, Lord, he is having no criminal antecedent as on today.
I
And
am not intending that.
Lord, one more thing. Lord.
कोई जरूरी है एक्सीडेंट नहीं होने से आपको बेल हो जाना चाहिए. ऐसा तो कोई लॉ नहीं बनाया है हमने.
मगर 6 महीना रह चुके हैं. कोई रिकवरी जो है, जो 2 मोबाइल 1 सिम है, मतलब your let's say may kindly peruse if there is any FIR. Your
There
let's
are
say
3 victims.
Huh?
There are 3 victims.
No, one of 5,000. Only one victim of 5,000, and that also, my lord, the SIM use has not been seized from the possession of the petitioner. That also does not tally. That I am saying, Lord. That also does not tally. That also does not tally, my lord.
What all has been recovered from the possession? Where is the season list?
Yes, madam.
what is the prescribed punishment for your offence? How much is the prescribed punishment? Yes, take. How much is
It is
the
not under
7 years.
7 years.
7 years.
See,
साइबर क्राइम के ऑफेंसेस में 3 ईयर है और अदर देन द साइबर क्राइम ऑफेंसेस चीटिंग है
maximum 3.
forgery है उसमें से
7 years.
There is the season list.
Not season is it is not the part of the affair, but it is in discuss not in page 12. Page 12.
Search and seizure memo is there in the.
But it is
in
not
the
supplied.
case diary.
Yes.
The case diary
Case
is
diary
there.
it is there. It is not there for your next this para 4.
These are standing in your name. All these C's are,
No.
are standing in your name.
One of them is in the name of the petition.
Which one is in your name?
That I am clarifying. That question.
And in your.
There is I have made a wrong solution. 3 victims is there. That by mistake I have made that.
कि हम अपने note में लिखे हैं।
नहीं yes
आप
last
बोले one victim,
last
ये भी
last
किसी बोले
last
victim।
occasion में 3
जब
victim
मेरा
हम
बात
बोले
है
थे
तब मैं बोलेंगे लॉर्ड
लास्ट ओकेजन में हम बोले थे
का यही बोल रहे हैं लॉर्ड
लास्ट ओकेजन में हम बोले थे 3 मगर
क्या 3 victim लिखे हैं?
yes last occasion I have given the noting there is
मैंने
3
काउंटर में
victim
डाला
5000 का ही है सब
5000
4 5000 5000
थोड़ा दिन वेट करो।
6 महीना हो गया 6 महीना हो गया
नहीं,
let's say we used to grant if there is no antecedent let's say we used to grant lots 6 months हो गया
every day is a new.
not every day but your lordship at least some your lordship में
एक नया view।
because I have नया view आज हमें इसी पर टेस्ट नहीं होना चाहिए इसी के लिए बोल रहे हैं let's say at least not any yes I was of the view I
बोल दिए।
नहीं no that I cannot say Lord client is
थोड़ा
that I cannot say only Lord any condition Lord the father will be beller each and every day any condition you let's say may impose
प्रॉब्लम क्या है कि रिपीट ऑफेंस का बहुत चांस
नहीं I Milord any condition if he repeats Milord his bail be cancelled Milord this condition may be imposed Milord I am ready to for that if it is repeated his bail bond may be cancelled that Milord
Please hold on for a while. This is quite serious. और आप देखिए, you just see the investigating officer of the case does not even write one letter to the other state as to whether any case has been registered or not. सारे केसेस में आपके क्राइम लिंक हैं। एक चिट्ठी नहीं लिखते हैं ये लोग।
इंडिविजुअल इस केस में लॉर्डशिप एसपी ऑफिस से मेरी कम से कम 4-5 बार
हाँ,
पर्सनली टॉक बात हुई है
they are not interested in conviction. They are interested in something else.
Yes.
Which I can see very well. Because we also see that in Jharkhand, in most of the cases, acquittal is because the seizure is not proved. और seize कौन करता है? पुलिस वाले. And seizure is not proved, the matter is over. यही कहानी है ना?
yes
तो बस
एक्चुअली इन्वेस्टिगेशन को क्लोज करके कि एक थाने में मेरा केस हुआ उसका इन्वेस्टिगेशन हम कंप्लीट कर
कंप्लीट तो कभी होता नहीं है।
नहीं वो कर क्या
one case your ladyship has already caught what happened after submission of charge sheet in one of the case your ladyship has asked that report also Milord but ये prove हो जाएगा what they are doing
इसीलिए चूंकि विक्टिम है रिकवर्ड आर्टिकल आपके नाम से नहीं है, ठीक है, तो कुछ दिन जेल में रह जाइए, बाद में एक्विटल ही होना है आपका, क्योंकि आपका तो सीजर प्रूव ही नहीं होगा।
नहीं कन्विक्शन होगा 3 साल का होगा 3 एकदम पक्का होगा 3 साल 3 साल का होगा।
ट्रायल एक्सपेडाइट करा देते हैं।
नहीं ट्रायल एक्सपेडाइट नहीं ये मेरा 3
आप बताइए ना अभी क्या स्टेज है इसका?
चार्ज शीट हो गया है चार्ज भी
कितना
चार्ज के बारे में नहीं लगता
I just 6 महीना रह गया है। This is the first instance है और any undertakings the father is ready to give any undertaking as because he has no other क्रिमिनल केस
आपसे कौन बेटा बाप का बाप?
नहीं मानता है, ऐसा बात नहीं है. Father is giving undertaking for you. Father is the affidavit also. Father has been any condition can be imposed.
ये जो हम लोग का झारखंड जो टॉप पे चल रहा है ना साइबर क्राइम में, इसको थोड़ा सा
झारखंड से ज्यादा टॉप तो
पहले
राजस्थान.
हम तो दूसरी चीज बोल रहे
राजस्थान
हैं। एक्चुअली है इनको 200 केस थाने में लॉन्च करने का जरूरत नहीं. केस 10 केस को ही अगर क्लोज कर देते हैं, इन्वेस्टिगेशन बीच में ही क्लोज हो जाएगा इनका. एक केस से दूसरा कनेक्टेड अगर उसको कनेक्टिविटी से जाते रहे तो हमको लगता है एक एक केस में एक 100 विक्टिम कंटिन्यूअस सारे सब कनेक्ट हो जाएंगे एक ही 2 केस में. ये लोग कर क्या रहे हैं कि एक केस हुआ, विक्टिम खोजे, दो सीजर बनाए, केस को इन्वेस्टिगेशन क्लोज कर दिया. इन्वेस्टिगेशन क्लोज होने का जरूरत नहीं है. इन सारे केसों में बहुत सारा चीज एविडेंसेस है जो नहीं लाया जा
आपको
रहा है.
बताइए वो दूसरे स्टेट्स में जो पेंडिंग, जब हम यहाँ पूछ रहे हैं कि दूसरे स्टेट्स में एफआईआर लॉन्च हुआ,
ये
एक
कुछ
चिट्ठी तो होना चाहिए ना.
Yes.
क्या तमिलनाडु एक लेटर भेजे?
Yes. In that, there are cases. Yes, there are cases in which, on the basis of that letters, the accused persons who are in custody are being remanded to
इस
Hyderabad,
केस में
Rajasthan.
कहाँ है?
इस केस में इनका नहीं आया, कहीं एफआईआर नहीं हुआ. मगर I have given also instances for your leadership in which one of the cases they has been.
इससे ज्यादा बेल में सुनने की
नहीं इसे तब इसको एक प्रयास है. हम कुछ दिन रहना है, 3 महीना और रह जाता है, इसको विड्रॉ कर लेते हैं. आप
नहीं.
विड्रॉ
ये नंबर
it will be tied up as
नहीं
after some arguments.
after some argument. We number 387/2026. For the Learned Council appearing on behalf of the parties, the Learned Council for the petition submits that there has been a seizure of. It is alleged that 2 mobile one SIM have been recovered from the possession of the petitioner, and further during investigation, 3 victims could be identified. The petitioner is in custody since
Since
25/1/2026. A supplementary counter application has been filed, where it has been mentioned that apart from
एक्सप्लेनेशन मांगा गया था इसके से.
yes, wherein it has been mentioned that altogether 1448 complaints has been found, and under the FIR column there is total 37 in number. However, in the report it has been mentioned that the report is intended solely for intelligence purpose and should not be used as evidence or court trials. Emphasis may be laid down on resolving cases/complaints with direct and AI linkages. The state is trying to project as if these figures are not to be utilized for the purposes of trial or otherwise. However, the Learned Council for the state has submitted that investigation is still going on to find out more evidence. The case study reveals that there are numerous triangles and that connecting the petitioner with the mobile, connecting the mobile which has been recovered/SIM recovered from the possession of the petitioner in numerous other states. The petitioner does not have any explanation with respect to the mobile/SIM which has been recovered from his possession, but they are standing in the name of other persons. In view of the numerous families and complaints having been registered in different states and investigation is still going on. This court is not inclined to enlarge the petitioner on bail.
At least.
It is always at least. Trial is like
Lord has said some more months, Lord, he will come, Lord, trial due.
just a moment.
Yes.
However, the state is directed to ensure that अभी क्या चल रहा है trial? Tracking of trial.
Start होगा. 1 मिनट होगा trial.
अभी एक ऑर्डर सुप्रीम कोर्ट को ऑर्डर आया है. Whenever any bail application is taken up, it is a duty of the state to inform the court at the spot what is the stage of this. तो इसका थोड़ा ध्यान रखेंगे. Stage के लिए हम लोग कोर्ट से मंगाते हैं. The bail applications are delayed.
ई कोर्ट से पता चल जाता है.
Yes. 1 मिनट.
Item 4, BA 4077 of 2026.
काउंटर का डायरेक्शन हुआ था लॉर्डशिप, काउंटर रेडी है, आज सबमिट कर दें.
Receiving का नाम
रिसीट लाइन. Sorry, sorry.
12 number of SIM card, mobile have been recovered from your possession. Correct? 12 number of SIM card, mobile, debit card, they are standing in your name.
10 debit cards.
They are in your name. Yes. They are in your name. Debit cards. They are in your name. बताइए ये सारे डेबिट कार्ड आपके नाम से हैं? कौन सी भाषा में?
मेरा कंफर्म नहीं है मेरा, लेकिन हमें बताया गया था 11 डेबिट कार्ड सीज हुआ.
वो तो सीज हुआ, वो तो दिख ही रहा है सीजर लिस्ट में. ये सारे डेबिट कार्ड आपके नाम से हैं? दूसरे के नाम से डेबिट कार्ड इतना आपके पास क्या करता है? यस.
मुझे बताया गया कि लॉट की पिटिशनर के नाम से
एफिडेविट फाइल एन एफिडेविट आपको बताया गया है ना?
नहीं.
फाइल एन एफिडेविट जो भी आपको पैनल ने बताया होगा. फाइल एन एफिडेविट दैट ऑल दीस डेबिट कार्ड्स आर स्टैंडिंग इन योर नेम. राइट? राइट. नहीं तो बैंक और ऑफिस का नहीं. बताइए केस डायरी में आया किसके नाम से है? Also for the petitioner submits that all the debit cards, all the articles which have been seized seized from the possession of the petitioner are standing in the name of the petitioner. Correct? File an affidavit. The counsel for the petitioner waits for some time to file an affidavit to support his statement, as no such statement has been made in the bail application. कितना टाइम चाहिए?
appearance.
The counsel for the state is also directed to file a supplementary counter affidavit to this aspect of the matter. File कर दीजिए आप. Close this case on 3rd of August. The supplementary affidavit of the petitioner and supplementary counter affidavit of the state should be filed on 31st. By the state is taken.
Item 5, BA 4090 of 2026.
It's a case of cyber offense counter affidavit has been filed. Since the recovery is of one Android,
Where is the CCS?
Caesar is part of a diary, but the recovery will be evident from the first information. So, recovery of one Android with 2 seal, along with the cash of 57,000. So, in the course of investigation, it has come that there are 10 crime leads, there is 2 victims, and one of them is 4 accused
This lady had no friend. This lady to whom we have granted bail had no friend.
Discount is there. Discount.
Show me, show me.
Yes.
So far as crime link of this lady who has been granted bail is concerned.
Para 57. Para 57 of the case. And there will go into that will also come in the top.
What is your status?
I have charges.
Yes. How many, what all PCs from your possession?
So we one Android with 2 SIM,
One mobile,
2 SIM.
two SIM, standing in the name of different persons.
Yeah, one is in the name of other person. That is the, and it there is a cash of 57,000. That was for the
Cash is a bill.
and the crime league, 10 crime leagues, that lady was having 6 crime leagues, and 2 victims came for
What is the
and
stage?
state charge against it. And they have no anticipated that is.
क्या बोलना है ये जितना बात बोले हैं सही है
Yes, yes. I'm verifying the case diagram.
trial has not been commenced.
No, charge is different.
When was the charge? Trusted person.
In custody, in paragraph 1 I have mentioned, in custody since 20 February 2026.
Charge को फिर
हम तुम्हें बता रहे हैं.
कोई बात नहीं. और the left counsel supporting on the other counsel for the petition submits that one mobile and two SIMs are alleged to have been recovered from the possession of the petitioner. And during investigation, the particular 10 crimes have been found validly the recovered articles from the petition. And 2 victims have been added. They submitted that the petition has been from the maximum charge has been paid. The petitioner is in custody suspended. Yes, further submitted that the accused, namely Mamta Devi, has been enlarged on bail by this court in PA number 3646 of 2026 by Robert Deputy by 2026. The learned counsel for the state, though has opposed the prayer for bail, however, the requested submission saying that the counsel for the petition is not used. After hearing the learned counsel for the parties and considering the fact that charge sheet has been submitted and the petition has no criminalization and court use, we similarly taken from the law maintained by this court, the petition is admitted to the court. How many co-accused are there in this case?
Some of them by coordinate benches.
हो गया.
You this lady said, "Mr. how easy my work is."
So,
तो आपका एक और
देखिए ऐसा नहीं है दूसरे कोर्ट का प्लेस करेंगे तो ऐसा
नहीं
नहीं
उसके
है
वो क्लाइंट लीड वाला भी पैरिटी पे था उसी वही
ऐसा नहीं
मतलब ये इसको क्या कैसे
इस कोर्ट का नहीं कोर्ट कोई भी जज साहब पास करे वो इसी कोर्ट का ऑर्डर and it is to be respected and I give full respect to any order which has been passed any court judgment इस तरह का नहीं हो सकता.
Item 6 BA 5313 of 2026.
बस एक ही डिफरेंस रहता है किसी किसी कोर्ट में कभी बिना केस डायरी के होता है तो हम केस डायरी देखते हैं. Yes.
On the last occasion, statement under section 183 BNS called for the statement made before the magistrate. The case registered under section 96 of BNS. 3 तारीख को 3/5 को शादी था लड़की का और 30/4 को घर से निकली. And she was subsequently opened on 6/4 after
183 BNS was taken. Yes, that's taken.
उसको मंगाया था उन्होंने स्पेसिफिकली मंगाया.
पढ़ाएंगे क्या? I'm not able to. It's not legible.
First and legible copy has also been
Was called for. Yes. She has not been any issue. Really like to just wait.
इस 10 तारीख को उस लड़की का शादी भी है शादी भी
Just record filling is only.
मुश्किल है स्टूडेंट जो 17 एग्जाम
So. Custody.
6/5/26
Age,
age petitioners
17 years. Victim's age,
she's saying that 17
It has now 16 years.
16 plus,
17.
less than 18.
less than 18
आपको क्या बोलना है मिस्टर रेलम?
As far the exam is concerned, the petition, I have received the instruction that the petitioner has not even submitted his semester fees and admit card has not been issued in his favor. So as far as the
Let's see on the merit. What do you have to say on the merit? Are you the informant of the case?
informant. Lordship, as the victim is a minor, so consent is immaterial. This petitioner took her to Gangtok, kept her there for 3
Gangtok?
Yes, Lordship. Yes, Lordship. Took her to Gangtok, that is out of this jurisdiction.
No, where to get this? She has not stated so in the statement, section 183. From where do you say that she went to Gangtok? She has
No.
not stated anything about it. उसके बाद में अपनी मर्जी से इसके साथ जामताड़ा बस स्टॉप पर गई, फिर इधर उधर की, फिर बाद में 3 या 4 तारीख को आना निकला. She has been recovered from Gangtok.
No,
Jamtara bus stop.
recovered from Jamtara.
At least have some kind of statements. For the letter process of being on behalf of the parties. Counsel for the petitions on the set of petitioner is 17 years. Is it possible since 6/1926? And he has been falsely convicted in this case. He has further submitted that the petitioner is a student and has to reduce exam. The learned counsel for the informant has approved a prayer for bail and has submitted that the petitioner has not even filled up the form. However, during the course of hearing, the statement of the victim recorded under section 183 BNSS has been placed, and the counsel for the informant has also gone through the statement. As per the statement, the victim has stated that she, with her own will, went with the petitioner to Jamtara bus stop, and then ultimately she came. No further allegations. After hearing the learned counsel for the parties and considering the statement of the victim recorded under section 183 BNSS, the petitioner is admitted to be in action.
From the daily list under heading for admission, item 1, BA 590 of 2026, along with item 2.
The allegations are very serious. The petitioner happens to be a 19-year-old boy. The informant happens to be a 70-year-old lady. She makes an allegation that
Direct allegation.
direct allegation. Now, what has happened? The informant had been examined. She has no notes that she said that I had only reported that my 7,000 rupees was lost.
Where is that?
I have
the state of the case? How many witnesses have been examined? So
The husband and the victim. 70-year, the victim, and
the
71
victim
years.
has turned hostile. Yes, ma'am. And for the informant. Informant is the victim also. You are turned hostile. So you should not be having any objection to bail. This is for both the persons.
Yes.
Their bail application was withdrawn. It will be nice. The learned counsel for the parties are present. These two bail applications have been tagged together as they arise out of the same matter, and both the petitioners are named accused and the citizen. The learned counsel submits that the victim is 70.
No, 60. No, the deposition may be 60, head is 70.
Victim is 70 years of age, and she and one more witness has been examined before the learned court, and both of them have turned hostile. He submits that as per the evidence of the victim, she had gone to the police station as her 7,000 rupees was missing, and she has even refused to identify the accused. The learned counsel for the informant has appeared and has submitted that the victim has turned hostile and she has no objection if the petitioners are involved. The learned counsel for the state also has nothing to say once the victim has turned hostile. After hearing the learned counsel for the parties and considering the alleged submissions, the victim having turned hostile, the petitioners are directed to be involved in ये दोनों का एक photocopy of the evidences of victim and one another witness is placed.
Appearance review. Item 3 DA 4988 of 2026.
And they've been on custody since 26/11. 26/11/2024. There is only one mobile, one SIM, one crime link, single crime link,
One mobile,
one crime link, one victim of 4,006.
one
Custody,
accident,
the one accident there.
one accident.
Therefore, I had withdrawn in brief. And two co-accused granted जिसके खिलाफ में क्राइम लिंक भी है और ये है सिर्फ एंटीसीडेंट इनका नहीं था और कस्टडी 26/11 से है. But crime link is at para 50.
Whatever he is saying is correct, madam?
Yes, madam. One working, one planting, and one accident.
For the learned counsel's opinion on behalf of the parties. The learned counsel for the petition submits that as the petition having one antecedent of similar nature, and in the present case, one mobile, one SIM, and one crime link has been found, and one victim has been identified. The petitioner is in custody since 26/11/2025.
Charge has been framed,
The charge has already been framed,
no witnesses.
but no witness has been examined so far. The bail application of the petitioner was already withdrawn. However, two co-accused have been enlarged on bail by PCA number 1205.26 by order dated 17/4/26. And in BA number 1302 of 2026 by order dated 10/4/26. The Learning Council for the state has opposed to therefore be allowed the aforesaid sanctions made by the Learning Council for the petitioner is not in dispute. Considering the custody of the petitioner, the petitioner is directed to be in. However, the state is directed to ensure that the witnesses are competent to the law. The Learning Council for the state is directed to committee this order to test the evidence and to the director of proceedings. Contract with the client and the proceedings.
Item 4.
In this case, I have two mobile phone with one SIM recovered. The SIM stands in the name of the grandfather of the petitioner.
Lordship, last date direction to file the controversial Lordship in case, case diary received your Lordship on the time for filing the account. I just received the case diary.
Council for the state pays for the jury to comply with the last one. Both is based on this one. The contract agreement should be private. Next Friday.
Yes, fantastic.
Next Friday is the justice. The contract agreement to be private.
Item 5. DT.14.07.2026. इसमें DC
Yes, ma'am.
The case is section has
It's not there.
sorry, it has been served on 13th of July. So 5 days. Because we have received the copy on cases under section 77 and 79 of the BA section 7 of the IPA. But the girl was aged around 14 years old. This is the earlier she was having to receive the friendship with the other body. Subsequently, as is stated, that is annexure 1 at page 27 in the it's a 5 line. Met so and
All the videos. have been-
videos you should that is the direct test come as per the counter affidavit filed by them. It is come that it was the Somnath Das. In the affidavit, your lordship, they say your lordship paragraph 17 that at para 84 and 89 the case that it is mentioned that the witness Tarandas uncle and Somnath Das landlord. Both have stated that Somnath Das provided password for the broadband. But they say the video, although there was the line which has been there, it's not the video your lordship. That is being used by the password of the Somnath Das your lordship. Somnath Das was having the broadband. And this is the password of the Somnath Das, and they say that the password
It has
is
been, you see,
provided to the Kailash Das.
That's true. You see, the time is on.
Charge has already been
Charge has
given.
been framed, one witness has been examined.
Yes, your
witnesses
lordship.
are there. How many witnesses are there?
How many witnesses are there? I have annexed the charge already. Your lordship. How many witnesses?
Your Instagram account.
In the Instagram account, when I say no videos named viral, but that has come in the diary. It's IPR 543, it's something like that.
It has been made viral.
Yes, that it's not the focus.
Or the letter comes.
Only some period because the charge is already.
We'll expedite it. Or the letter comes to supporting on behalf of the parties in the council for the petition, some is the petition is in custody since.
He is in custody, your lordship, since 31st of October 2025.
31/10/2025. The charge has been
Framed.
and trial is in progress.
Charge has been framed on 8th of April 2020.
Charge has been framed on
April 2020.
8 April.
8th April. I have annexed the
8/4/26.
Yes.
And one witness, only one witness has been examined.
Which I got it through phone unit yesterday. the client said ki one witness has been missing.
It has
Although I'm not
got the status.
I'm not annexed, because when I felt that.
They have got the status.
Yes.
The council said that the petition has been falsely reported in this case. Actually, the network which was utilized
Was of Somnath.
was in the name of
Somnath Das. Yes.
Somnath Das. He's a co-accused.
No, he's not a co-accused, he was a landlord over there. He said that the password was
He
given
was
to
the
him
landlord.
for the study purpose.
He was the landlord over the premises, and the password of the line was given
To him for the study.
for purposes of study. The Learned Council for the state has opposed the mayor for going and has submitted that numerous videos has been recovered, and numerous vulgar videos have been recovered, and the mobile was used, and Instagram account was also used to make the videos viral.
Your Lordship, videos would not be covered. They say at para 11, Your Lordship, as per their contact with it's not, it is mentioned that after analysis from technical side, details of the Instagram ID, some words, lovely cute princess 579, then phone number, it was on the, the videos have not been recovered, which I'm not saying, I'm reading
Just
your
a moment.
it's not the
Just a
same.
moment. In different Instagram, it has been alleged that different Instagram accounts were used to make the video viral. That has come in the case. After hearing the Learned Council for the parties and considering the seriousness of allegation made against the petitioner in connection with the victim age,
Victim age is 14 years as per the school.
14 years,
As per the school.
and the trial is already in progress. This court is not in time to invite the petitioner on behalf. However, the state is directed to ensure that the remaining witnesses are promptly produced before the court. The Learned Council for the state is directed to communicate this order to the SP of the concerned district and director of prosecution. These photos, videos are already there in the case. Very nasty.
No, Your Lordship, from the, there were the two accused persons, Kailash Das and the other. So far this Kailash Das is concerned, that is their counterfeit in the diary.
You have
also, Your
explained
Lordship.
with your
The videos are not from his mobile, because there were the two co-accused.
You have
First
explained.
बोलते हैं कि दोस्ती मेरा एक से हुआ, subsequently जब
दोस्ती भी गलत होना मुश्किल है आज के दिन में।
नहीं, but that is her version, Your Lordship. But videos जो है दूसरे से हुआ है, from her she says कि इन्होंने लिखा कि cute
You have
princess
explained
like
your
this.
trial, madam, if the witnesses do not come, you can just leave.
Yes.
Item 6 BA 4993 of 2026.
It is a case under section 80, clause 2 of the BMS. It has been alleged in the FIR by the brother of the deceased that her sister was subjected to cruelty for the sake of dowry, and so then she has been murdered by the strangulation. Now, Lordship has been pleased to call for the case diary on the last occasion, and the counter has also been filed. It is apparently clear, Lordship, from the PM report that
Where is her matrimonial home? Where
Lordship,
is the matrimonial home of this petitioner?
nowhere,
Of the
Lordship.
victim?
They have done the love marriage, Lordship, and they are residing together. Both are working.
Where they were deciding?
Lordship, at that time, at the time of this occurrence, they are residing in the Tukudana, Lordship.
So that was her matrimonial home.
Yes. Rented house. Now, Lordship,
Because the petitioner is not from Jharkhand. Petitioner is from Delhi.
Yes.
His address has been mentioned as Delhi, so I was just confused.
No,
Where is the matrimonial home of this
Lordship.
late who expired?
My lord, I say, Lordship, that Lordship may kindly have a look at the para number 293 of this section. Once 293, thereafter, a letter written by this petitioner to the SSP Ranchi, and the suicidal note is annexed. Yes. 29.
Yes.
A letter was written by this petitioner after the occurrence in which he has clearly stated that what is happened in this. Now, Rashid, the most important thing that the informant is saying that her sister was subjected to cruelty for the sake of dowry, for the demand of dowry. But the suicidal note, there is nowhere it is mentioned by the deceased herself that she has ever been subjected to cruelty or any kind of dowry demand has been made to her. The reason behind this is some other.
So
It has been clearly written.
So before dying, she gave a suicidal note.
Yes, yes.
How is it in your possession?
But so then.
And you are writing a letter from somewhere else. Why did you take away the suicidal note?
But what has happened? What has
No,
happened?
let me just understand.
Yes, yes, Lordship. It has been also explained in this letter, Lordship, that after this said occurrence, I was very much depressed, and I have taken that note. I went to anywhere, Lordship. It has been written by me.
So you were tampering with the evidence also.
No.
But that means this only.
No. जो हुआ क्या कि वाइफ हमारी जो है वो फांसी लगा घर गए देखे मेंटली डिस्टर्ब हुए उसका नोट पढ़
Intercaste marriage.
यस
Inter-religion.
इंटर-रिलीजन
And the most important thing is the witnesses who went at you found a house bolted
From
from outside.
Yes.
Yes.
I know.
नहीं जो तो उसमें यही हुआ हम घर आए देखे कि वाइफ हमारे जो फांसी लगा ली हम बहुत ज्यादा डिप्रेस्ड हो गए नहीं सुसाइड नोट लिए चूंकि जो विक्षिप्त हो गए थे इन्होंने लिखा भी इस चीज को कि चूंकि हमें कुछ भी सोचने समझने की शक्ति नहीं थी इसलिए हम
Yes. हाँ.
What happened? She is a Muslim and he is a Brahmin. Both of them met together through Facebook. He came from Delhi to Ranchi. She is already in Ranchi. Then her parents' father is not there. She is having only mother and brother. She left her parental house, came to him and started residing in Tripura. Both of them were working. Now the question arose, Your Honor, that she wanted that he should convert in Muslim. He wanted to get her converted into Hindu. And that was the main dispute, and that is reflected from the Honor suicide note. Kindly go through the suicide
No,
note.
we are not here. We are not doing that trial.
Correct, Your Honor.
Your conduct is very serious.
Now, my Lord,
Your wife found dead. You come home. You see her lying. You see her hanging. You take away the suicide note.
no, my Lord.
This is what you are
That is why I just wanted to, my Lord, explain. And it is written here also. When I found that she was hanging, I made a call to her brother. I made a call to her sister.
We are not here.
And then, my Lord, two, three things only, my Lord. 2, 3 things. Not more than that. I brought her down. She lied down. And then, my Lord, they threatened that we are coming with 100 Muslims. He is not from Ranchi. He did not have anyone in the anybody. So once they threatened that they will come with 100 people, normally it happens. Then there were chances of riot, may not into Muslim riots. So he fled from there.
So you are safe in the jail.
That is why kindly see the postmortem report.
You
Only 2 things I will say.
I want you enough. Apart from bail, what do you want? I can give you expeditious trial. The investigation is over.
Charge sheet filed on 30th March. Charges are filed. 30th March.
They mentioned that para is
No, I found correct.
Just a moment. आप एक second रुकिए. Out of 11 charge sheet witnesses.
None have been examined.
ये बहुत गलत बात है. Witness नहीं examine करते. You can't
Charge,
put him in jail.
charge is, I have a friend on 16/5/26,
16.
just two months back.
आपका expeditious trial is your right.
Around 30th March.
झारखंड में आप देखिए कितना तेजी से trial. Just wait and see.
I say only 6 minutes more. On 30th March, charges were filed.
The charge was framed on 16.
No, my lord, it is only written. It is only written. I say this.
Only written
I say before the bar, my lord. 30th March.
Stated so.
My lord, it is only typed. It is only typed.
Typographical error.
Typographical error. It is charges were filed on 30th March. On 23rd, my lord, cognizance was taken and charges were filed on my lord 30th March. And thereafter, we are in July. None of the witnesses have been examined. My lord, only one submission more. My lord, kindly see the post-mortem report. What the doctor said. And my lord, I will rely only on 2 judgments, my lord, of my lord, on the same issue, my lord. I will not go beyond that. My lord, it is a discretionary power. My lord is having vast power, and that is what, my lord, I will just, my lord, 2 judgments my lord, I shall refer. Can you see the post-mortem report? Nothing, my lord. He has not done anything. The question is, she wanted that he should convert in Muslim. He wanted that she should convert in Hinduism, and that is why she has committed. She has written the same statement in her suicide note. My lord, kindly see page 4, paragraph 15 and 17. One innocent person should not be behind the bar, my lord. They are having, my lord, faith in law. My lord, kindly have 15, my lord. There must always be, my lord, page 4. I am just reading, my lord, the relevant.
Page number.
My lord, 4, page number 4 of the judgment, my lord.
Of this judgment.
Judgment, my lord. There must always be proximate and live link between the effects of cruelty based on body demand and the concerned death. In the case of a Hinala matters, state so and so. In paragraph 9, it was observed as an blind reading of section 113 of Evidence Act and section 304(3) IPC shows that there must be material to show that soon before her death, the victim was subjected to cruelty or harassment. But not soon before her death. The prosecution has to rule out the possibility of a natural or accidental death so as to deem within the purview of a death occurring otherwise than in normal circumstances. The expression is soon before is very relevant under section 113(b) of the Evidence Act and section 304(b) IPC are placed into service. The prosecution is obliged to show that soon before the occurrence there was cruelty or harassment, and only in that case the presumption operates. Now, I would kindly have just para above 16. Intervals should not be much between the cruelty element or harassment concerned and the death in question. There must be existence of a proximate and live link between the effect of cruelty based on body demand and the death concerned. Or kindly have para 17. Applying these principles to the instant case, we find that there is no evidence as to the demand of body or cruelty, and that the deceased currently was subjected to body harassment soon before her death. Except the demand of the scooter, there is nothing on record to substantiate the allegation of body demand. So, my lord, and another my lord, one more judgment, only my lord.
The same point?
No, my lord, another point is about postmortem. Postmortem.
What do you want to say? We are
My lord, I just
not undertaking, I do not know.
My lord,
We are not undertaking trial over here. This is a judgment post-trial.
My lord, I just wanted to say 2 things. My lord, kindly
Your
say.
conduct of running away with that suicide note does not inspire confidence.
My lord, only one thing, my lord. My lord, there was chances of right, my lord. I was alone. She is having family of 100 people. Everybody came on the spot, my lord. Once we came to know later on, police has found out. And police initially, my lord, kindly see the case. Police has lodged the case of murder. And thereafter, after investigation, my lord, they found that it is a case of body death. And when They received the suicide note, my lord. Then they came to the conclusion that it is a case of suicide. My lord, there are three things: murder, then dowry death, and then suicide. This is the case, my lord. My lord, kindly see page 18, para 70, my lord. What is the High Court says, my lord, on this?
What is the date of the FIR?
My lord, 23/11/2024, my lord.
When did you send the letter?
My
When
lord,
did you send the letter?
in 2025, my lord, I will see the date.
One year you take to send.
1/11/2025. For the
1/11, after 1
My
year.
lord, I was taking treatment, my lord. I was totally depressed because I was boycotted by the society. My lord, I belong to a Brahmin family, married to a Muslim girl. So my society boycotted me. I cannot go to my home. I cannot live in my society. And so I was taking medicines for about 1 year because the entire world is finished, my lord. That is my lord, kindly see the pathetic condition. His entire world is lost because he boycotted to societal norms. He may not left everything for his love, my lord. And the girl said, my lord, kindly see, you are not hearing to my parents' voice. That is why I am committing suicide. My lord, the girl says in the suicide note, my lord, kindly see, I have lost both. I have lost my world, my society. I have lost my wife, my lord, and then I am in jail, my lord. So my respectful submission is, my lord, kindly see, 4 months is passed. I am for about 7 months in jail, my lord, more than 7 months. I have surrendered voluntarily, my lord. I did not fly away. When I recovered my lord position, when I came to the normal condition, my lord, I came to the court. I surrendered before the court, my lord, and then I went to the my lord. This suicide note was my lord recovered from me, and it was my lord. There I was sent in jail. So my respectful submission is, my lord, an innocent person who has no role in the same, my lord, in this society. She has stated in her, my lord, suicide note that
Caution application filed.
no, no.
That
My lord, I will not
that
do
is the
that.
best solution.
No, my lord, no. My lord, I will pray only one thing, my lord. My lord, kindly see the condition.
I am telling
Every
you,
case is not.
I am telling you, your conduct does not inspire confidence. After 1 year, you write a letter. In your entire bail petition, not even a word has been mentioned regarding your treatment, your mental condition, you are being treated by, not even a sentence is there, and I am not used to hearing anything which is beyond the
My lord,
records.
kindly see my letter, my lord. In letter it is written.
That letter you don't bother about.
In the written, my lord, is my lord, the police has filed this letter has
I've
been
heard
filed
you
by the
enough.
police.
I've heard you enough.
My lord, my lord,
मेन में इससे ज़्यादा सुनने की जरूरत नहीं है. People are waiting for their turn.
my lord, my lord,
I
two
will
sentences.
expedite. आप बताइए ना next date कब है? आपका गवाही आएगा, आप बताइए.
My lord, 18th को है.
हाँ, 18th
My lord,
को आएगा ना 18th को. Yes, counsel. Yes, I'm asking you.
Yes.
हाँ, बताइए.
My lord, I will request only one
आप
thing.
कहाँ से आते हैं?
आते नहीं सर for this purpose because he is an innocent
कहाँ से
person. My lord, I have
आते
come
हैं?
from Delhi. I have come from Delhi.
आप जरा देखिए कि झारखंड में expeditious trial कैसे होता है. You need to see that.
My lord, the problem is, my lord, trial will go on, my lord. It is a case of suicide.
ऐसा नहीं होगा.
Around 15
This
to
is what
20.
I'm saying. झारखंड में समय बदल गया है. यहाँ पे ऐसा नहीं होगा.
No, my lord, sir,
Witness
sitting
नहीं
my
आए.
lord.
Witness नहीं आए. SP will be under contempt and you will be released.
My lord, 4 months is passed, my lord. None of the witnesses has come till today, my lord.
कोई
My
बात
lord,
नहीं.
kindly see, my lord. Only just a minute, sir. I have to pursue my lord.
नहीं,
My lord,
I
kindly see, my lord. No, I have to pursue my lord, kindly see two things, my lord.
have heard
My
you
lord,
enough.
my lord, I just wanted to say two things. That's all, my lord. Kindly see the circumstances. It was a question of my lord right, and so he had no option. He had no
देखिए,
option.
आप पे दिल्ली स्टाइल का बहस यहाँ नहीं चलता. जो चीज पिटीशन में नहीं है वो हम ना सुनते हैं ना देखते हैं.
My lord, it is there. That is why kindly see page 86. It was filed with the police. My lord, I have not filed it. It is filed by the police, my lord, along with the charge sheet. Page 86, my lord, kindly see.
Yes, yes.
It is written.
Now you please, we have heard you enough. Now you will listen to the order. VA number 4993 of 2026. Heard the learned counsel's opinion on behalf of the parties. The learned counsel for the petitioner submits that the petitioner happens to be the husband of the deceased. And there was religion love marriage between the petitioner and the deceased. And the petitioner came down from Delhi and ultimately settled in Tulana with his wife and both were working. He further submits that on 23/11/2024, the FIR was lodged when his wife was found dead in the rented house where the petitioner and his wife were residing. The learned counsel further submits that when he saw his wife dead and he apprehended that some right may take place, he took away the suicide note from the place of occurrence, and thereafter he wrote a letter to the SP annexing a copy of the suicide note. The letter is dated 1/11/2025. The learned counsel submits that the petitioner was not in right mental state, and therefore he took 1 year to send a copy of the suicide note to the SSP. The learned counsel submits that had the petitioner not run away from the place of occurrence, there was all chances that the right would take place. The marriage was organized when? The marriage was organized in the year 2022. The learned counsel has further submitted that there is an allegation of demand of dowry and assault upon the deceased. However, he has relied upon the judgment passed by the Honorable Supreme Court in the case of Major Singh and Ananda versus State of Punjab, reported in Manu/SCOR/021/2010, and has submitted that in absence of approximate and live link between the demand of dowry and death, the conviction under section 304B cannot be sustained. And the accused therein was acquitted by the Honorable Supreme. The learned counsel has also referred to the postmortem report and has submitted that there is no anti-mortem injury. She died of hanging and she was found lying on the bed. He has submitted that the petitioner had taken her down and then put her on the bed and ultimately took away the suicide note, bolted the house from outside and ran away to save his life. The petitioner is in custody since
3rd January 2026.
3/1/2026.
Surrendered before the court.
As he has surrendered before the court, the charge has been framed on
30th March,
33/2026, and it has been inadvertently mentioned in the bail application that the charge was framed on 16/2026. He has submitted that not even a single witness has been examined so far, and petitioner is in custody for almost 7 weeks, having no. कुछ छूटा आपका
नहीं, 60 को
बस
त्रिपुरा हाई कोर्ट का जो जजमेंट है
क्या त्रिपुरा हाई कोर्ट
आपने एक जजमेंट कोर्ट कर दिया है तो इसको भी कोर्ट कर
काफी है सर जेल के लिए जजमेंट बहुत है
तो मेरा
the learned counsel for the state has opposed the prayer for bail and has submitted that
three lines FIR is there. Only 3 lines FIR.
one line में काफी होता है. The learned counsel submits that as per the postmortem report there is ligature marks in the upper neck which is anti-mortem in nature.
And therefore due to asphyxia due to hanging.
Page number 20 is here.
Death is due to asphyxia due to hanging. they have submitted that there is clear allegation made against the petitioner in the FIR itself. And he has managed to evade his arrest since 23/11/2024 and surrendered only on 3/1/2026. After hearing the learned counsel for the parties and considering their project submission and the fact that the deceased was found dead in a house where she was residing with the petitioner, and the house was bolted from outside. And also the fact that the petitioner, after 1 year, has written a letter to the SP along with the suicide note. And the argument of the petitioner reveals that the petitioner ran away with the suicide note, which he says in order to save his life. This court, under facts and circumstances, is not inclined to enlarge the petitioner on bail. However, there can be no reason on the part of the state not to produce the witnesses before the court. The learned counsel for the state is directed to ensure that witnesses are promptly produced before the court. Counsel for the state is directed to ensure to communicate this order to the SP of the concerned district and also to the director of prosecution. If the witnesses are not promptly produced, the responsibility will be fixed upon the SP. Communicate with you.
May I request only one question? At least kindly grant me liberty after the examination of the cases made out.
After the examination of witness to file in a control होगा.
नहीं मेरा उसमें ऐसा है कि जो भी पब्लिक विटनेस है उसके बाद में मेरा at least kindly grant me liberty.
You can file your bail application every day.
No no. Unless मेरा grants me right to मेरा कोई other case मेरा is aware.
यहाँ पे रोज फाइल कर देते हैं।
No, मेरा
यहाँ 10 दिन बाद भी फाइल कर देते हैं।
let other people file. But I will not file.
I will entertain if you file.
Unless my lord grants me liberty after examination of witnesses, my lord, at least this sentence may come, my lord.
Item 7 DA 5001 of
The whole
2026.
purpose will be defeated, my lord.
आप देखिएगा हर डेट पे विटनेस है। Next date कौन सा बताया आपने?
18th.
The learned counsel has for the petitioner has submitted that next date in the trial is on 18th of July.
Today is 14th.
तो क्या 4 दिन में आपका विटनेस नहीं आ जाएगा? एक विटनेस काफी।
I will write letter today.
आज अपलोड हो जाएगा। तो अपलोड करना सुन ले।
But in this case, I think is there yet called for dependency of the charge sheet has been submitted.
डायरी में क्या है?
डायरी में तो हमारे क्रिमिनल एक लिंक बता रहे हैं और एक क्रिमिनल इंसिडेंट।
What has been recovered from the
Nothing.
Nothing has been recovered.
Two mobile, one SIM.
Two mobile, one SIM. Standing in your name. किसके नाम से?
हाँ मैं जिसके नाम से लिंक बता रहे हैं पैरा 11 में लिखी मेरा वो मोबाइल।
नहीं मोबाइल आपका है कि नहीं?
मेरा एक नहीं है, एक है।
एक one victim. Yes. And how many crimes? One of 6 crimes. 6 crimes. And antecedent.
एक।
196 also.
उसमें कोई were arrested.
Similar nature. Custody कब से?
4 actors has been
Custody
29/3/2024. 300 half. 2 equals have been granted. 4 persons were arrested. And Raja has also 6 wallet transactions. That first one. That on page 27 it has been observed by the session officer. 4 persons were arrested. Roman, you know, 27 में राजा का भी 6 valid creation, 7 transition में भी
Found the learned counsel appearing on behalf of Counsel for the petition submits that the petition received custody since 29/2026. Two mobile, one SIM is alleged to have been recovered from the possession of the petitioner and one victim has been identified. There are 6 claims. The council has also submitted that the petitioner has one human accident. He has further submitted that similarities with cases namely Neeraj Das, Dilip Das, and Raja Kumar have been enlarged on bail in VA number 4775/26, VA number 4778/26, and VA number 476/26. By order. The learned counsel for the state has opposed the prayer for bail and has cited that the petitioner has criminal antecedents of similar nature. After hearing the learned counsel for the parties and considering the fact that the petitioner has one criminal antecedent of similar nature, this court is not inclined to enlarge the petitioner on bail. So far as the two accused are concerned, their bail was granted on the condition that there was no victim were identified.
Why victim?
Just a
Why
moment,
victim में है?
उसमें no victim, that was a
हाँ
submission.
वही सबमिशन उसकी तरफ से था
तो क्या करें?
हमने तो
However, the petitioner may renew his prayer for bail after
4 months.
थोड़ा कस्टडी होने की 4 महीने बाद.
Item 8, VA 5.05/2026.
The case was registered under section 103(1)61 of the BNS Act. But subsequently, charge sheet has been submitted under section 108. Even charges has also been framed under section 108 of the BNS Act.
इन्फॉर्मेट को इसमें हमने बना दिया.
Informant को so
नहीं and he's received, yes, he's received the notice.
he has already been served.
Yes.
One witness has been examined.
Yes, out of 12 charge sheet witness, one witness has been
Who
examined.
are you?
Yes.
Keep that quiet, please.
So 12 charge sheet witnesses were there.
Keep that quiet.
But as per the allegation in the first information report,
पढ़ते हैं ना.
the informant happens to be the daughter of the father of the deceased. And as per the allegations in the first information report, it is alleged that the petitioner, who happens to be the husband of the deceased, was having extramarital affair, which was being objected by the deceased. As a result of which, it is said that the petitioner, along with his all the family members, used to abuse and assault the deceased. And on the alleged date of occurrence, it is said that the deceased was murdered by administering poison upon her. And as such, FIR was registered against 4 accused persons, including the petitioner.
In the FIR on 10/9/2025,
Yes,
in the evening at 5 o'clock,
yes.
the deceased had called her mother.
But this is the allegation that on
That she was
10/9/2025, the deceased has made a call to her mother, and thereafter it is said that the incident regarding assault was said to her mother.
नहीं, बस मार रहे हैं. She
मार.
was being assaulted.
But ये allegations है as per the first information. My humble submission is that the marriage of the deceased with the petitioner was solemnized 12 years prior to the accident. Out of the wedlock, 2 children were even born, and thereafter the relationship was cordial in between the petitioner and his wife. But deceased consumed poison on her own, and as the case, as of now, charges have been framed only under section 108 of the BNS Act. There is no allegation whatsoever with regard abatement or instigation on the part of the petitioner upon the deceased to commit suicide. There was some matrimonial rift in between the deceased and her husband, who happens to be the petitioner. But out of that reason, she consumed poison on her own and she committed suicide. There is no abatement or instigation on the part of the petitioner, and the petitioner is in custody, my lord, since 12/9/2025, and he denies any extramarital relationship. The most
बच्चे कितने बड़े हैं?
यस, 10 और 12 साल के बच्चे।
उनका स्टेटमेंट रिकॉर्ड नहीं किया? यस,
नहीं
स्टेट
नहीं,
उनका स्टेटमेंट का कोई वैल्यू नहीं है।
that is
What
not there
kind
in
of
the
investigation is this? Yes, their statement also has not been recorded. बच्चे तो सही बताएंगे कहानी, असली स्टोरी बच्चे ही बता। Cause of death क्या है?
because of pressure of research.
FSL
FSL report
has received.
No.
Or the learned counsel superior on behalf of the parties. The learned counsel for the petitioner is the husband of the deceased, who was married in the year 2013 and had 2 children. Further submits that as per the allegation in the FIR, the petitioner had illicit relationship with someone, which was being objected by the deceased. And it is also alleged that the petitioner used to assault the victim, the deceased. But as per the FIR, she died due to poison. He has submitted that the cause of death has not yet been ascertained, in view of the fact that the sample has been sent for examination by FSL. Custody counsel.
12/9/2025.
The petitioner is in custody since 12/9/2025. He has further also stated that even the statement of the 2 children has not been recorded in the system. The learned counsel for this, he has then submitted that there was matrimonial discord and his wife committed suicide. The learned counsel for the state has opposed the prayer for bail. However, the posted submissions made by the counsel for the petitioner is not in dispute. It is further not in dispute that charge has been framed under section 108 years. And the FSL report is still awaited. After hearing the learned counsel for the parties. And considering the aforesaid facts and circumstances and charge having been framed under section 108 for claims and the cause of death is still to be ascertained through the FSL. The petitioner being in custody since 12/9/2025 is directed to be enlarged liability. The state is directed to ensure that the FSL report is produced before the FSL. Also for the state is directed to communicate the order to the FSL branch.
Item 9, BA 5038 of 2026.
On the previous date, statement basis of 183 case diary was brought for.
Your
The trial in this case administered under section 609 of BNS and in the FIR, there is allegation that this petitioner in the context of
He has fully supported the case. The victim has fully supported the case. What was the age of the victim?
18 years.
18 years on what day?
On that
Charge sheet has been submitted under which section? FOXO is there or not there?
approximately.
FIR में क्या था सब?
FIR में इसी के लाइन में।
flashing this section.
69.
69.
And
From where do you get this?
there is 45 days delay in the
This. She was staying in a hostel.
Yes.
क्या हो गया?
The condition is institution of the sexual assault on critics of the management.
She has also stated that she has developed the relationship of love with the petitioner. Custody कब से?
15/1/2026
Charge तो पे ही
नहीं मालूम लेकिन as per my instruction I got yesterday that 3 cases have been examined.
witness of how many witnesses? How many witnesses have been examined? How many witnesses have been examined?
3 have been examined and total witness I have not got any instruction. Yesterday I got
Victim has been examined.
victim probably has been examined.
How the learned counsels of hearing on the witness. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case. And the statement recorded in section 183 of the ASS would reveal that the victim stated that she developed love relationship with the petitioner while she was staying in the hostel. The petitioner, the victim is major and victim को notice हुआ है ना?
Yes. Instruction.
The victim was major and charge has been framed under section 69. 69 of the AS. The learned counsel for the state has opposed the case with the understanding that as per the allegation, the petitioner has established relationship with the victim and extra knowledge. And there is direct connection. To this, the learned counsel for the petitioner submits that 3 witnesses have been examined.
3 have been examined. That's
But
what
he is not aware as to whether the victim has been examined. यही है आपने
नहीं victim की instruction है कि examine करेगी और तो वो हुई he knew
and he submits that the victim has also been examined. After hearing the learned counsel for the parties and considering the statement of the victim recorded under section 183 BNSS, where she has also stated that she did love relationship with the petitioner. And The victim has already been examined and there is no right to withdraw. And in view of the statement and section 183 and the victim having already been examined, the petitioner is directed to the hospital.
Appearance as in. Item 10 BA5040/2026.
May it please the judge. Offences under section 80 subclause 2, 85 and 3 subclause 5 of the BNS. Petitioner happens to be the husband of the deceased. Now first your lordship may kindly have a look at the post-mortem report. The case diary was called for yes, counter. Now from the post-mortem report,
We'll see that if I first. What is the date of marriage?
date of marriage is April 2024. May I please. Page 15 is the written. निवेदन पूर्वक कहना है कि मैं स्वयं पुत्री स्वयं की शादी प्रीतम कुमार उर्फ चंदन पिटिशनर के 7 अप्रैल 2024 में 5 लाख रुपए नकद, एक सोने का चैन और करीब 3 लाख का घरेलू सामान देकर धूमधाम से किए। शादी से कुछ दिन तक ठीक से रहने के उपरांत मेरी बेटी का पति प्रीतम कुमार उर्फ चंदन, ससुर अरुण किशोर, सास बबीता देवी मेरी बेटी को दहेज के लिए प्रताड़ित करने लगे एवं कहने लगे कि तुम्हारा बाप शादी के में सब नकली सामान दिया है, दोबारा सब सामान नहीं लाओगे तो तुम्हें घर में रहने नहीं देंगे, तो वह मार कर फेंक रहे। उसका पति उसके साथ लगातार मारपीट कर बोलता था कि मेरी बेटी को तलाक दे देगा और दूसरी शादी कर लेगा। यह बात मुझे मेरी बेटी फोन पर बताती थी। करीब 9 माह पहले मेरी बेटी गर्भवती थी, उसी दौरान तीनों लोगों द्वारा मेरी बेटी के साथ काफी मारपीट किया गया था, जिससे हमारे गांव के लोगों एवं रिश्तेदारों द्वारा समझाने बुझाने के बाद अच्छे से रहने के लिए हो गए थे। आज दिनांक 20/12/25 को समय करीब 13:45 बजे मुझे अपने रिश्तेदारों के द्वारा the postmortem report, it reveals that it is a case of suicide and no external injuries were found on the body of the deceased. Only one ligature mark, which was encircling the neck on the upper part of the neck, and the doctor has given the finding that the cause of death is asphyxia due to antemortem hanging. Now, from the postmortem report, it appears that it is a case of suicide. During the course of investigation, it has been mentioned in the case diary also. If your lordship may kindly have a look to, certain paragraphs have been mentioned, wherein it has been stated that at the time of alleged occurrence, the petitioner was on duty in the bank and was not present in the house. Paragraph 9 of the counter after. If your lordship may kindly have a look. It is there in the case diary, paragraph 77, 78 and 79, that he was not present at the place of occurrence. Now the important statement is of the mother of the deceased, which is there at Kandika 34, if your lordships may kindly have. This is very important. Your lordships, I am placing करीब 3 लाख रुपए घरेलू सामान दान दहेज देकर किए थे। आगे बताए कि शादी के करीब 3 महीने बाद
इनकी बेटी जब इनके घर आई तो इन्हें बताई कि इनकी सास पति शादी में नकली सामान देने तथा दहेज कम देने का ताना देकर गाली गलौज और मारपीट करते रहते हैं। पहले भी इनकी बेटी अपने गुतनी के फोन से कॉल करके यह बात बताई थी, तब ये अपने दामाद को फोन पर समझाए थे। आगे बताया कि इनके समझाने के बाद भी इनके दामाद तथा इनके सास ससुर इनकी बेटी को लगातार प्रताड़ित करते रहे और मारपीट करते रहे। करीब 9 माह पहले इनकी बेटी के साथ काफी मारपीट की है, तो हम लोग कुछ रिश्तेदारों के साथ लड़का के घर गए। लड़का तथा लड़का के घर वालों को अच्छे से समझा कर आए कि मारपीट नहीं करेंगे, अच्छे से रहेंगे। आगे बताया कि दिनांक 20/12/25 को समय करीब 13 बजे इन्हें डाल्टनगंज के बैंक के माध्यम से पता चला। नाउ फ्रॉम द स्टेटमेंट there is no such allegation that any dowry was demanded. The only dispute was that the ornaments or other things which was given, it was found to be artificial by the accused persons and they were scolding the deceased for the same. From the statement of the mother, there is no such demand of dowry. Therefore, in my humble submission,
कम देने का कारण मांग।
हाँ, दहेज कम देने का, but there is no such demand. There should be demand of dowry for attracting Section 8. Now, similar is the statement of the other neighbors, and taking into consideration the postmortem report, it appears to be a case of suicide. No case under Section 80 of the BNS is attractive. And in the similar circumstance, the other co-accused persons, they have been granted bail by this honorable court. We have annexed the order.
Mother-in-law and father-in-law.
And the finding of the investigating officer in the charge sheet, we have annexed the charge sheet also. In the charge sheet also, it has not been mentioned that there was any demand of dowry. There was certain dispute with regard to the gifts already given at the time of marriage, but there is no such allegation of any demand.
But the death is within 7 years of marriage. That is precisely within 1 year, 8 months. There is allegation of demand of dowry, and the witness have supported the case that she was being continuously tortured for the demand for the dowry that was less given at the time of marriage, or as recently it was not as per the not 13-14 by the father of the deceased. So the witnesses have supported the fact that she was continuously tortured in this regard. And unnatural death has occurred at the matrimonial house.
Dowry is the compensation.
Section 80, 340 of IPC, 380 of BNS.
Charge sheet has been submitted.
Charge sheet has been submitted under Section 80, 85 and 3/5 of the law.
Or the only council superior.
But the ingredient of Section 80 is not there because it says that the harassment by her husband or any relative in connection with any demand of dowry. There is no such demand in the.
Or the only council superior on behalf of parties. The only council petitioner submits that the petitioner is the husband and his wife died within 1.5 years of marriage. But it was a case of suicide, and and she died due to hanging. No other antenatal has been found on the body. The Land Council has also submitted that on the basis of evidence, the petitioner was found working in the bank, and this has come during investigation. The Land Council proposed letter to the statement of mother of the victim, and they submitted that the allegation was that the gifts given during marriage were found to be artificial. And therefore she was being tortured and assaulted. The petitioner is in custody since
Since 22nd of December 2025.
22nd, 2025. The FIR was launched in the month of
It was
20th of
20th of December 2025.
FIR.
FI 20/12 का FIR है 22 को.
25. The only council state for the informant was supposed to pay for being and they submitted that charge has been given under section 80.
Charge sheet.
Section 80 of BNSS. And there is clear allegation of assault of the deceased by the petitioner. And the witnesses have supported the allegation. He has also submitted that there was that earlier also when this when there was assault by the petitioner upon the deceased, there was some consideration. After hearing the new chances of giving and considering the fact that there is allegation of torture of the deceased in a matrimonial home, and there is an allegation that the petitioner has been assaulting the deceased who died within 1.5 years of marriage in a matrimonial home. This court is not inclined to enlarge the petition on the
Item 11, BA 5042 of 2026.
Yes, Your Lordship, yesterday.
Yes,
Section 69 of BNS and 4 of the POCSO. Now,
one entity was taken.
Yes, Your
One entity was taken.
now the affidavit which has been filed by the informant prosecutors. If your lordship may kindly have a look to.
Let me just open this. Both are major. She says that she had some love affair.
And that is there in the counter affidavit filed by the informant.
Custody person.
I'm in custody since 21/5/2026. Age is 35 years.
35. Victim is
20 years.
As per the Alabama.
And she has claimed in the lower court also, she has filed a petition for withdrawal of the case in below. What they have stated in their counter.
or the new councils of the on behalf of the artists. POCSO में लेकिन registered हुआ है.
POCSO में हुआ but she herself claims to be 20 years of age. और FIR में 17 years बोली थी इसलिए POCSO में registered.
इसमें 17 years, 183 million.
But your lordship may kindly have a look to her counter affidavit, which has been filed yesterday.
18 years.
Aadhaar card में
Aadhaar
as per the
20
Aadhaar
years.
card 20 years.
All the current council supporting on behalf of the public sponsored by the petition says that he is interested in since the 1/2026. And he has been responsible to the ministers. He has further submitted that as per the fire itself, the petitioner and the victim by having relationship for last 1 year. And she used to love the petitioner. The learned council has age gap of verification.
Yes, it is from page 9 of the case diary. As per the later issued by the headmaster of the government school, the date of birth of the victim was found at 1/1.
She was major. She was major on the date of offense. 1/1/2010.
Yes. She was minor at the time of offense. As per the
But as per X-ray report,
yes,
approximately 18 to 19 years.
And she herself claims in her petition filed before the learned court below to be 20 years of age.
Charge sheet इसमें also में भी हुआ.
Charge sheet अभी नहीं.
आरोप पत्र को जमा हो.
मेरे
69
पास-
BNS and section 6.
under section 6 of process.
The council for the petitioner has submitted that. Even in the statement recorded under section 123 DNSS, she has stated that she has love affair with the petitioner. The learned counsel for the informant has submitted that as per Aadhaar card, her age is 18 years. 20 years.
And later issued by the headmaster.
Yes. The learned counsel for the state has submitted that as per the letter issued by the headmaster, the date of birth of the informant victim is 1/1/2010. However, as per the medical report, she was found to be 18 to 19 years of age. The charge sheet has been submitted on section 69 BNS as well as on section 6 of the POCSO. However, after hearing the learned counsel for the parties and considering the statement of the victim recorded under section 183 BN6, where she herself has stated that she was in a love relationship with the petitioner for almost 1 year. And charge sheet having already been submitted, the petitioner is directed to the So we will
Item 12, BA 5049 of 2026.
This is statement.
Evidence is
Out of 12, 3 cases have already been examined.
the custody murder. Date 6/2022. There is no allegation of
8/6/2023.
This is not the excellent mark. Allegation and this petitioner murder, they disclosed to the petitioner murder the other than the accused person. They assaulted and they committed the murder of the deceased. And this petitioner, they didn't participate with them. Although murder the
You are not with the bail application earlier. पहले bail application नहीं
No,
था।
no, is the first one.
Yes, calculation of these two, we can expedite it.
No, there is no direct allegation. This is not the allegation of the, he is not the accident man. He is not the accident.
But if there is a name that you are not possible.
That's it.
अभी पाया नहीं सब कुछ होगा क्या? और कुछ होगा इसमें?
ये बोले हैं कि other than 80 persons they have come to the mother. इसको ही बोला गया, ये बोले कि हम नहीं जाएंगे तुम लोग जाओ.
The uncle of the informant disclosed that on 5/6/23 at 9:20,
Yes, ma'am.
he was at his home in intoxicated state.
Yes.
Then the other named accused person asked him to kill the deceased, which was declined by him, and that thereafter the other named accused.
It declined. Thereafter, other accused persons they went and they committed the murder, and he was the intoxicating condition. He was in his home.
The informant asserts that her uncle wrote the petition along with other named accused persons conspired with each other and committed murder of his mother on the allegation of that which by slitting her throat.
On the allegation of the conspiracy against him. And often, and short weapon was recovered on the basis of the confessional statement of a accused person. On the basis of this petition.
Where was the weapon recovered from?
On the basis of confessional statement of who is mother.
Yes, what you say?
Yes, ma'am.
Yes, dead.
Shankar
Confession
Munda.
के अलावा क्या? Confession के अलावा क्या?
फिर जो विटनेस हमें सपोर्ट किए हैं
आई विटनेस है?
एविडेंस नहीं है.
नो आई विटनेस.
लेकिन घटना के दिन
कस्टडी कब से?
घटना के दिन डिसीजन का झगड़ा भी हुआ था. अब लेकिन वे नशे में थे तो दूसरे को क्यों उनके पास आए थे.
कस्टडी कब से? 8/6/23.
8/6/28.
ट्रायल के लिए क्या पूछता है? जेल में रखे हुए हैं. इंप्यून ऑर्डर 28/2/26 का है. अभी तक कोई 10 का करा नहीं. For the limit concentration on behalf of the parties, the counsel for the petition submits that the petition has been falsely implicated in this case and has found that the petitioner was in an intoxicated condition and had conspired to commit the murder of the deceased by slitting her throat. The learned counsel submits that except confession statement of the petition, nothing is there on record, and the murder weapon has been recovered on the basis of confession statement of the accused. The petitioner is in custody since 8/6/2023. The learned counsel for the state has opposed the prayer for bail. After hearing the learned counsel for the parties and however, prayer for bail, however, he could not point out any other material from the case diary except the confession statement of the petitioner. After hearing the learned counsel for the parties and considering the custody of the petitioner since 8/6/2023, the petitioner is directed to be enlarged on bail. However, the state is also directed to ensure that the remaining witnesses are completely before the court. The counsel for the state is directed to communicate this order to the SP of the concerned district and also to the director of the city.
Item 13 BA 5050/2026.
Petitioner has been located in case registered for non-offence under section 107 of BNS, which corresponding section of 306 of BN of the Code. It has been alleged in the FIR registered as the father of the deceased girl, page number, page number 40. It has been alleged that he had gone outside the house on 15/7/2025. In the meantime, 15/7/2025, and when he come to his house, he found that the body of his daughter lying. Someone informed that it is lying near the backside of his house, that is a forest area, in which his dead body was in hanging condition. It has been alleged in the FIR that there was a love interest between the petitioner, and therefore he has suspicion that due to which I was not behaving with her well, and therefore she has committed suicide. It has, in course of investigation, it has found that the petitioner was in relationship with the victim, but there is no evidence with respect to any bad relationship has come. And it has been also been in the fact that some video was also there in the prior to clear. There is no such, there is nothing on this diary or any other evidence has come that it was either recovered or found during the investigation. And once it admitted case that she has committed suicide. There is no injury, nothing. Postmortem report was called for. This petitioner has got no criminal antecedent. Charge sheet has been submitted.
What do you say? State, before the government?
Yes, ma'am.
Yes, what do you have to say? They say that except preparation statement, there is nothing against the petition. And it only alleged that there was a love relationship between the petitioner and the victim. बातचीत का the cause of death क्या है? Asphyxia. Any antimortem?
No.
Any antimortem?
Lordship, para 44 of the Syria reports, kindly see the para 44 of the case.
दोनों में बातचीत
ये टावर लोकेशन प्राप्त हो और इतना para 44 मंजीत टुकड़ो मृतिका संध्या कुमारी एक दूसरे लगातार संपर्क थे। इसके अंतराल दोनों के बीच 9 बार कॉल एसएमएस के माध्यम से हुआ, जिससे 9 बार कॉल हुआ, जिससे पति मंजीत टुकड़ो मृतिका से दोनों एक दूसरे लगातार संपर्क में थे।
Of course, but date of death का
16/7/25
15/6/25 से लेकर 15/7/25 15/6/25 से 15 और ये वीडियो वायरल का ये लॉर्डशिप काइंडली सी द एफआईआर
कोई उसका रिकवरी
ठीक है। काइंडली सी द एफआईआर लॉर्डशिप मैंने स्वामी पता के जंगल पर भैया कुछ हम लोग ने मतलब बेटी संजय 17 के रूप में 17 साल 17.5 मेरी बेटी संध्या उम्र 17
2008 की
3% का बातचीत होता था। उसमें एक बार मेरी बेटी का एक आपत्तिजनक वीडियो भी वायरल किया गया था, जिसके कारण मेरी बेटी संध्या कुमारी दबाव और तनाव में रहा करती थी। लड़की के मना करने पर भी मंजीत टोपू उसको फोन करके परेशान करता था। मेरा विश्वास है कि मंजीत टोपू के द्वारा लगातार मेरी बेटी को बातचीत करने के क्रम में दबाव बना एवं उकसाने के कारण मेरी बेटी संध्या कुमारी ने दिनांक 15/7/25 को फांसी लगाकर रखा कि जब तक ये बात करते रहा 15/7/25 तक ये आई पर सीढ़िया
कोई वो वीडियो नहीं मिला,
नहीं मिला
वीडियो नहीं मिला, नहीं मिला। नो देयर इज नो सच वीडियो, देयर इज नो सच। कोई ना
और ये 15/6/25
केसेस बोले हैं कि हम लोग को उसका कोई जानकारी नहीं है। उसके लड़की के भाई ने बोला है कि इसका कोई जानकारी नहीं है, और कोई वीडियो हमारा नहीं मिला। और दूसरा कॉल एक तरफ से नहीं है, दोनों तरफ से कॉल। ऐसा नहीं है कि हम ही कॉल किए हैं। जिस पैराग्राफ में ये दोनों तरफ से इनकमिंग जो है वो ज्यादा है और गोइंग मतलब हमारे फोन में इनकमिंग लड़की का ज्यादा है, लड़का का हमारा जाना कम। वो पैराग्राफ
There are several.
हम जो वो दिए उसके बारे में बोल रहे हैं।
आप उनको तो बोलने नहीं दे रहे।
Yes, Lord.
उसी लोग बोल रहे हैं बोल लें।
क्या बोलना?
Yes, Lord. The several witnesses supported the prosecution story. It is the clear states, Lord, कि kindly see the page number para 3. Para 3 of the informant, restatement of the informant Ravinder Badai. He states कि मैंने देखा कि मेरी बेटी विस्टार से पेड़ में फांसी लगा ली, जिससे हम लोगों ने उतारा, पर मेरी बेटी की मृत्यु हो चुकी थी। मेरी बेटी संध्या 17 वर्ष का बगल में गांव के लड़के मंजीत चोपड़ और ये सच प्रेम प्रसंग में था, और मेरी बेटी का एक आपत्तिजनक वीडियो वायरल किया गया था रिट्रीट, और सेम स्टेटमेंट ऑफ द विदेश पढ़ाई लॉर्ड्स इट आल्सो स्टेटेड कि मंजीत टोपो के द्वारा मेरी भतीजी का आपत्तिजनक फोटो वीडियो वायरल भी किया गया था, जिसके बाद हम सभी परिवार वालों ने संध्या को मंजीत टोपो से दूर रहने को समझाया था। मंजीत टोपो आवारा किस्म का लड़का था, पढ़ाई लिखाई नहीं करता था, संध्या कॉलेज एडमिशन करने वाली थी। संध्या कुमारी के काफी मना करने पर भी मंजीत टोपो उसे परेशान करता था, और मेरा विश्वास है कि मंजीत टोपो से परेशान होकर मेरी भतीजी ने आत्महत्या कर ली। This is the investigation. And also statement of the मनमोहित पढ़ाई repeated the statement। मुझे संध्या कुमारी मंजीत टोपो के प्रेम प्रसंग को एक बार से जानकारी थी। मंजीत टोपो के द्वारा मेरी बहन का आपत्तिजनक फोटो या वीडियो वायरल किया गया था।
वो एज कितना था?
मेरा 20 साल 19 साल
उनका एज होगा।
आया मेरा एज भी
About the constitution of the parties. The constitution of the petition is that the petition is in custody since
16/4/26
16/4/2026. Charge sheet has already been submitted. It says that as per the allegation, the petitioner was having an affair with the deceased, and in the FIR it has been mentioned that she was 17 years of age, and her objectionable video was made viral, and the petitioner used to trouble her by repeated calls, and ultimately she committed suicide on 15/17/2020. The learned counsel says that no video has been recovered during investigation. And
FSL report आ गया लॉर्ड्स।
falsely implicated in this case. The learned counsel for the state has opposed the prayer for being
FSL report कॉल बस
and has submitted that the episode report in connection with the mobile has already been received, which has been placed on record. The learned counsel further submits that there are numerous calls between the petitioner and the deceased immediately in the vicinity of the date of occurrence, and the petitioner used to trouble the victim beyond a point, and ultimately she committed suicide. And there are other witnesses on record who have supported the prosecutions. The learned counsel for the informant has also supported the submissions made by the learned counsel for the state. After hearing the learned counsel for the parties and considering the fact that there is direct and specific allegation made against the petitioner, and the call records have already been examined through forensic. This court is not inclined to enlarge the petitioner on the
कॉल वाज में बोथ द साइड्स
of the petitioner is hereby disputed.
द कॉल वाज बट
The state
बोथ
is
द
directed to ensure that the witnesses are active before the court. FSL report court में चला गया?
FSL report
यहाँ पे तो है
हाँ कोर्ट में
the FSL report be also sent to the court concerned. Produced before the court concerned by the SP of the concerned state. You ensure compliance.
The call was from both the
Item
sides.
14, BA 5084 of 2026.
No, last year the case died on the statement of the victim. That was accountant announce the father. Control.
Is a direct allegation.
You recently only just for many submission. You recently para 9 of the contract. I'll get to the next one basically.
Yes.
That appears from para 28-26 of the case, right, that the petitioner was arrested from his house. And also made in confession before the petitioner and victim like each other since their childhood. And in the year 2022, by making a plan with his friend, he called the victim girl and his online marriage with her in Madhav Mandir, Nanjamab. When the villagers got to know about their marriage, they along with the family of the girl apprehended them and separated them from each other. And for this offense, Kunda PS case number 93 of 23 has been lodged against him. He further stated that they were in love and used to talk to each other for last 2 years, but for the last 2 or 3 days, the petitioner was getting the number busy, therefore he came to the house.
मंदिर में शादी वैलिड है. एज कितना है?
14 4
ये
months.
तो 2-3 साल से कहानी सुना रहे हैं.
पहले भी एक FIR इंसिडेंट
में
है.
क्या?
4 months.
One incident also is there.
But the
And
counsel
it's
is waiting on behalf of the parties. The learning counsel for the petition submits that the petitioner is in custody since
In custody since 27th of February 2026.
27 to 2026. And he has been falsely implicated in this case. There was love affair between the petitioner and the victim, and he has recorded a paragraph 9 of the case diary, which relates to an incident of the year 2023. And he has submitted that the petitioner and the victim were in love affair with each other and it's organized marriage in some temple. And in connection with that, one Kunda PS case number 93 of 2023 has been lodged against him, in which the petitioner has been enlarged on bail. The learned counsel for the state and the informant have opposed the bail for bail and have submitted that after being enlarged on bail, the present occurrence has taken place. The statement of the victim recorded under section 183 of the PNSS has been placed on record and edited in victim is anonymous. After hearing the learned counsel for the parties and considering the requisite facts and circumstances, there was already a case against the petitioner in connection with the victim in the year 2023. And now the petitioner has committed fresh offense again against the victim. The victim has supported the case against the petitioner in a statement recorded under section 183 PNSS. Accordingly, this court is not inclined to enlarge the petitioner on bail against it. The counter affidavit filed by the state society.
Item 15, BA 5092 of 2026.
This relates to cyber offense. Petitioner has got no criminal business. One mobile phone and 2 SIMs were recovered. Classic has been submitted. Now charge has also been printed in 14/5/2026. There is one victim in which there are certain 14 of there is a transaction of 14 of
What has been recovered from them?
one mobile phone and 2 SIMs.
They have been learning.
Yes.
All of them.
Both SIM, one mobile and SIM.
All the things they are standing in your name.
2 SIMs.
Both
Yes.
the SIMs are in your name.
Yes, yes, yes.
And the mobile is also in your
Yes,
name.
yes.
How many victims?
One.
One. Antecedent,
No.
any primary,
As per mine was no.
custody,
Custody. One. 13/1/2026. 6 months. And one of the quick.
there is problem. आपको क्या बोलना है?
But paragraph 41 says that there is a victim event. And it's very clear in.
And नाम है petitioner.
Ranjit Parmar. 41 में 20,000 माफ
During technical inquiry, kind link were found in NCCRB W portal.
How many, where are the details of the crimes?
The SIM which mobile number and the SIM which has been recovered, that has been linked.
Where is the details of the timing so far as the petitioner is concerned?
Para 1 and 2 के
Petitioner का crime link बताइए.
Not page number 2 देखा था केस डाली था. End. पत्नी की जांच अभियुक्त रंजीत बर्नवाल पैरेंट पत्नी की जांच के क्रम में अभियुक्त रंजीत बर्नवाल ने मोबाइल पर इतना शिकायत की प्रकार है. And the next page goes on 1 2 3 4 5 6 7. Online financial fraud, online.
आपके ऊपर कहीं और कुछ केस नहीं करना? ये सारा केस
कोई केस नहीं.
The letter transmitted is taken directly to instructions from the SP of the concern of Saraikela Kasama with respect to the handling found against the petitioner in NCCRB 14 and as to whether any FIR has been lodged against the petitioner or the mobile number or in connection with the crime. Affidavit by the DSP. आप लोग तो करिएगा नहीं कोई काम. The affidavit to be filed by next Friday. Who's this case on? But you the counsel for the petitioner submitted that the petitioner has no criminal antecedent.
Item 16, BA 5114 of 2026.
The offense is 103 of like yes. Corresponding to 1002 of them. So charged and submitted answers in 108, corresponding to 306 of them.
I think I'm wrong. April 2015. Incident. एक
426
एक साल. Your husband.
I'm the husband. शादी हुआ है couple 2 years.
Correct. सही बताया.
जी.
What is the cause of death? And where was she found?
She was found dead in my house, and the cause of death is hanging.
And what is the read the FIR? What is the allegation?
Yes. Page 18. ये तो पता करना है कि मैं रेखा देवी उम्र 45 साल पति से जनसंख्या साहिबगंज की निवासी मेरी पुत्री काजल देवी उम्र 27 साल का विवाह वर्ष 2025 के अप्रैल माह में दिलीप लाल पिता तिलमान लाल के साथ हिंदी विधिवश के साथ हुआ था. जिसको शादी के बाद से ही उसके पति सास ससुर एवं देवर मिलकर मेरी पुत्री काजल देवी की और मायके से पैसे मांग कर लाने के लिए मारपीट का प्रयास करते रहे. This petitioner was not found in the place of offense. At the time of his, as per the CDR report and the investigation report also, he was at Ghaziabad.
Okay, वो इंजरी तो है नहीं, she has committed suicide. आप गाजियाबाद में रहिए या लंदन में रहिए, इससे क्या फर्क?
So with the paper 306 we have I have been given in this case. The only experience we have found civil authority. Is the
Or the legal counsel agreement of the parties, the legal counsel for the petitioner submits that the petitioner is the husband of the deceased. And charge sheet has been submitted on section 108 of IPC. The deceased has various such. The deceased has committed suicide. The learned counsel for the state has opposed the prayer for bail. The learned counsel has also submitted that at the time and date of appearance, the petitioner was in
At Ghaziabad.
at that. The learned counsel for the state has opposed the prayer for bail and has submitted that there is that allegation against the petitioner in connection with assault and demand of dowry in the FIR itself. And his wife was found dead in matrimonial home. She has committed suicide. The case against the petitioner is now resolved. After hearing the learned counsel for the parties and considering the valid and specific allegations against the petitioner in the FIR itself, and his wife was found dead in matrimonial home within 1 year of marriage. This court is not inclined to enlarge the petitioner.
Item 17 BA 5122 of 2026.
Notice was issued.
What for the foods for the income? What for the income?
Today.
Leave that there.
ये जरा मैं सचिन से चलाने वाली हूँ 27/2/26 को शाम को मेरी बेटी सचिन से चुनी दिमागी हालत ठीक नहीं था वो डरी और शर्मी और रो रही थी तो मैं पूछा इशारा करते हुए बताई कि मेरे गांव के ही चाचा सचिन सच कहे कि मेरी बेटी को घर में बुला कर ले गया पक्का कॉलोनी घर में ले जाकर गलत काम किया तब मैं सचिन सच के घर में जाकर मामला तो गाली बता दिया ये बात किसी को बताओगी तो थाना में जाओगी तुम्हारा परिवार को ध्यान मानो No, she's not retarded, ma'am. Kindly see her statement.
Her statement, yes.
Diary was called for and statement of the victim has been called for.
Statement could not be recorded because she could not be false.
And that has been recorded, ma'am. That I am placing. Yes.
That has not been recorded.
183 you have.
Nahi recorded one. Could not be recorded as a victim is unable to speak.
But before police has stated her statement is in the record, ma'am. I have in the diary.
चीज मानेंगे कि हम आपका चीज मानेंगे.
I am submitting in the diary her statement is there at paragraph 180.
Once you say that her statement under section 183
180.
183 has not could not be recorded because she is unable to speak.
Then how it has been recorded that is in the diary part of the diary. That is the part of the diary.
But the court says that she was not able to speak.
Either the statement of the police officer is not correct or the court because her statement has been recorded. Kindly see her statement on the internet page 13 of the case diary speaks a lot matters. What she has said. Completely different story. She also says that what 3 to 4 points from her statement. हम बताए कि मेरे सच किए थे मेरा
Which paragraph?
Paragraph is not page is 30 matters. Statement of victim. Recorded paragraph is after paragraph 25. Copy which has been. Next page. Paragraph 25 internal page 13. I'm not missing my mistakes. She also is a student that has also come. Then once in her statement it appears that she had sustained injury on her private parts. Then kindly see the injury report that is at paragraph 57 of the case. What has been found by the because a lot of things has been mentioned. What is the injury report? internal examination. No any injury found. External part of those. Those chronicles was also found there.
Episode report,
This medical was conducted almost after 8 or 9 days.
8 to 9 days.
9 days. FIR, yes. FIR has been also on 4th of March 2026. While the
Fifth month.
fifth. And occurrence
On the
is
very
of
next day,
occurrence is of 27th of February.
27th.
They lost case after more than a delay of 6 days, but for that there is no explanation why they have lost the case. As per the statement, she had sustained severe injuries which has not been in the injury report. That I want to sure. And she says that prior to this, he had been regularly establishing physical relationship with her. That is also the statement of the victim.
Or the learning council secretary on behalf of the parties. The council for the petition says that the petition is in custody since
He is in custody since 5th March 2026.
5/3/2026. Charge has been submitted.
Yes.
Charge has been paid. Charge sheet has been submitted. The learning council submits that
Charges being.
as per the allegation that there is delay in filing of FIR by about 6 days. By 6 days? Delays by 6 days.
Yes, ma'am, because the date of occurrence is that is not mentioned already, only date of report is there, that column is vacant.
Even the charges in favor, one of the deposition is also with.
On 27 years, my delay is 6 days.
Delay is by 6 days. And the statement of the victim has been recorded under section 180 BNSS, wherein she submitted that the petitioner committed rape upon her and she also sustained injury on the private part. He further submits that the medical report does not support any any injury on private part and no proof of recent intercourse has been recorded. The learning council further state and the informant have submitted that there is direct and as specific allegation against the petitioner and the victim is just 14 years of age. And they submitted that the track is commenced and what witness has been examined. The records of the case reveal that as per the letter issued by the learning court, it has been stated that the statement of the victim under section 183 BNSS would not be recorded as the victim was unable to speak before the learning judicial magistrate at the time fixed for recording the statement. The order sheet of the court reveals that the petitioner remained completely silent and did not speak before the court. The learning council for the state after hearing the learning council for the parties, the learning council for the state and the employment and procedure. After hearing the learning council for the parties and Considering the medical examination report of the petitioner, it was conducted on the very date on which the statement was said to be recorded by the police, wherein no injury at all was found, the petitioner is directed to be investigated.
The injury, the doctor had examined it on 5th of March. The occurrence was of 27th of February.
Before we meet the recent traffic having arguments.
Within 1 year of marriage, after 11 years of marriage.
After
11 years of marriage.
11 years of marriage.
From 15 में शादी हुई।
After today, कुछ तो काम क्या डेट होता है?
तो अप्रैल 15 25 to 15 after 11 years.
ये वाला जो इसका ऑर्डर रिकॉर्ड करते हैं कल भेजेंगे। If you are it again, कोई बात नहीं, भाई अगर मान लीजिए कुछ गलत सबमिशन में या कुछ गलत रिकॉर्ड हो गया है तो we can always do it, right? And it is in your presence, it is being done. We are posting it tomorrow, which is at the joint request of the learning informant कहाँ? Informant नहीं है। Informant to notice it. That could be better. Also, for the state is directed to serve notice upon the informant parents. Is that yeah? And file an app. Yeah, file your counter. Counter में informant को notice करेगी. No. Post this case on 27. The service report upon the informant should be filed latest by 24. ध्यान से कर देंगे इसको। 11 साल और 7 साल में फर्क है, बहुत फर्क है। आपके सामने ऑर्डर लिखा है तो आप ध्यान नहीं दिए? आपके सामने ही ऑर्डर लिखा है तो आप ध्यान नहीं दिए?
15 or 25 में confused हूँ। Yes, sir.
From the production list, ready for press filing item 1 WPS 4819 of 2026.
Layer of the petitioner with respect to the cut-off date fixed by the JSC in the advertisement of 2026 with respect to
he has not informed the state. State is not party because the requisition is of the state court.
Where is the state?
And on the basis of the requisition, we have issued the
advertisement. The advertisement, the clause which is under challenge.
The state उनको requisition भेजता है, state terms and conditions of advertisement भेजता है, state इसका cut-off date भेजता है. This is the, they are just recruiting agency. State is a party.
State is a party alone.
Where is the state?
It may be taken out 250.
नहीं ऐसे नहीं होता है. Please don't.
On the last occasion when I was arguing this matter, it was objected by the council for the JSC. The state was not objecting at that time, ladies. And now they are taking
बहुत अच्छा है, consent लिखा देते हैं state का और आप order कर देते हैं आपके favor में.
Therefore, I am only requesting it to be taken out 259. I will request the state council to.
No, the case number 4819 of 2026.
Even a small intelligence may be given.
This case has been mentioned by the petitioner. However, the council for the state has not been informed about the mentioning of this case. The learned counsel for the Respondent,
JSSC.
JSSC has submitted that it has been issued upon the requisition by the state. And in their absence, no order can be passed. Suppose this case, in view of the opposing facts and circumstances, no order can be passed in this case with respect to the interim relief sought for.
Item 18 from daily list, BA 5126 of 2026.
Also, a list of all for the case diary as well as a statement under 183 BNS also. Petitioner the victim has stated that she herself went to Amritsar and there's a victim age तो 15 साल है आज पर जो इंफॉर्मेट का स्टेटमेंट है पैरा 22 of case diary और the learned court below has assessed the age of 16 years. She has stated that she herself went to the Amritsar. There is no question of any kidnapping. It demonstrates the case of informant person. He has stated that her sister was kidnapped. He has stated in paragraph 25, 30, 33, 34, 37. She declined to go for medical examination also. It has stated in paragraph 37 also.
I could say only two things. First thing is that notice was duly served and I have filed an affidavit. That notice they received the notice. Second thing, age of the victim as per the school record, paragraph 22 of the case at that is page 5 of the case at but it was recorded as per the school certificate 1111.
Headmaster का certificate.
And as per that, she is below 18. And charge is also submitted under POCSO.
उसमें तो 96 के applicable नहीं है, 64 के applicable नहीं है. Okay, say herself went to the herself went to the Amritsar.
The victim herself went to Amritsar and stayed with him.
One to three
And stayed with him.
and married
The learned counsel has submitted that the petitioner has been falsely accused in this case. The learned counsel of the state has opposed the prayer for you and submitted that the age of the victim that the date of birth of the victim is 1/1/2011. And therefore she was certainly minor on the date of offense. And attachment has already been submitted. To this,
Under POCSO Act.
under POCSO Act. To this, the learned counsel for the petitioner has submitted that the victim has got married with the after hearing the learned counsel for the parties and considering the aforesaid facts and circumstances and victim being minor. The petition, this court is not inclined to enlarge the petition on any शादी भी करनी है minors.
मैंने शादी हमने किया
वो जबरदस्ती शादी कर रही है.
खुद बोल रही है फलाने का ओपिनियन है जो 96 तो applicable भी नहीं है 96 is not applicable and 64 is not applicable also only date
Notified case under heading for orders item 1 BA 6463 of 2026.
I have been filed for provisional bail, Your Worship, for 2 weeks, Your Worship, during the pendency of the bail application, as the brother of the petitioner has died in a road accident, Your Worship. For attending the brother's
5/7/2026.
लॉर्डशिप 10th को इनको मिला है, वहाँ से लिखवा के लाए हैं लॉर्डशिप, और हम रिटन एक कंप्लेंट भी किए हैं बिफोर ऑफिसर इंचार्ज लॉर्डशिप। उसके बाद ये 11th को बंद था लॉर्डशिप, 13 फॉर्म फाइल किए हैं लॉर्डशिप। There's no male member in the house lordship, एक छोटा सा बच्चा है जिनका डेथ हुआ है, वही नहीं लॉर्डशिप कुछ दिन बाकी है लॉर्डशिप, 2-3 दिन बाकी है। आप लॉर्डशिप
बार चाहिए
बार
क्रिमेशन तो हो चुका है।
क्रिमेशन हो जाएगा और अटेंडिंग द रिचुअल्स।
क्या बोलना है?
कंसर्न पुलिस स्टेशन से रिपोर्ट मंगा रहा है, कल के लिए रखा जाएगा उससे।
कल के लिए कहाँ का मैटर है?
बोकारो में।
हम एक मिनट लगा के
बार डेट होगा ना,
हम डेट एक बार वेरीफाई
कुछ भी लिखे नहीं एप्लीकेशन में, क्या समझेंगे?
जो यूनिवर्सिटी डॉक्यूमेंट में था हम एक बार वेरीफाई इसको कल पे रख लिया जाएगा।
Each reflective application has been filed for grant of provisional leave to attend the last rites of the brother of the deceased by submitting that the
Brother of the petitioner.
brother of the petitioner it is submitted that the petitioner is the only male member in the family to perform the last rites. The date of death is 5/7/2026. The learned counsel for the state is directed to seek instructions. And
कल तो 10वां होगा।
कहाँ है? बोकारो। And file an affidavit of the officer in charge of the concerned police station with respect to the prayer for provisional leave by the applicant. Was this case they are clear?
कल 10वां है लॉर्डशिप, फिर वो 11वां फिर निकलने में भी
By tomorrow कर दीजिए, ऑर्डर अपलोड कर देंगे, कल शाम तक भी कर देंगे, तो भी कर देंगे।
इसको सेकंड हाफ में
Second half में ठीक है, was this case to be taken up at 4:15 ये ऑर्डर 1 है, सो इसको पेमेंट अपलोड कर दीजिए।
From the daily list, item 19, BA 5133 of 2026.
May I speak? This FIR has been lodged under section 103 of BNS, and but subsequently after investigation, the charge has been submitted under section 108 of BNS. The informant is the father of deceased person, and as per the FIR, there is stated कि जब ये 4 साल की थी तभी मेरे शादी और फैमिली को वोट मिली, और तब से बहुत प्यार से रखते थे बड़ी हुई, लेकिन जब फैमिली का डेथ हो गया तो बाकी फैमिली मेंबर स्टार्टेड हमारे व्यवहार करने लगे, गाली गलौज करते थे, कभी बातें भी करते थे और इस तरह से करते थे। So it has found out that during investigation, there was said that in the case that it also that one witness has said that he rose to डांट करके आरपीट की और थोड़ी देर बाद पता चला कि ट्रेन में जाके गिर गई। That is the allegation. And my submission is that कि हम लोग उसको छोटी बहन की तरह बहुत प्यार से रखते थे, ग्रोइंग अप एज में कभी डांटे हैं, पीटे हैं, या उसको पढ़ाई के लिए बोल रहे थे, उसमें ये सुसाइड करी। It has also come in the FIR that वो लड़की बोलती थी ले जाओ, ये लोग भी बोलते थे ले जाइए, but the parent, the father never lodged any complaint or any FIR anywhere, ना तो कुछ पंचायत में कि भाई मेरी बेटी को टॉर्चर करना है, लोग वापस चाहिए, never complained. Other than that, no allegation is received, and the postmortem report also said that the asphyxia will be resolving and otherwise no antibiotic needed. मारपीट करने का ये ऐसा कुछ भी बोल किया है adapted case that is admitted case but growing का पेन में बहुत तरह की बातें हैं लड़की बड़ी हो रही है उसको ढूंढना पड़ रहा था ऐसे तो and parents का एकदम तो कोई डाउट नहीं रहता है कि देने पर उनको ले जाने के लिए भी कुछ होने के लिए उनका बड़ी पूरी होती है ऐसे ही ना तो कभी ले गए और ना कभी कोई कंप्लेन लॉन्च की कहीं भी कुछ भी नहीं ये सारे
रंजन सिंह का भाई सुबेक सिंह रंजय सिंह पिटिशनर उन्हीं के ऊपर है अभी जो तो सारा जो ऐसे तो कॉमन एंड कॉमन एलिगेशन है बट उस दिन के बारे में है कि कोई डांटे थे मार्केट किए थे उसके बाद वो जाके एंड दीस पीपल आर लिविंग इन दिल्ली नो दिल्ली में एक भाई रहते हैं दैट हैज क्लेम्ड दैट जो दिल्ली में जो भाई रहते हैं तो वो भाई फोन करके बोले कि ले जाइए जो हम लोग को मारेंगे मारते हैं तो ये बात आया है जो एफआईआर में है तो वो ले जाइए जब बोले तो भी नहीं लेके गए बार बार बेटी भी बोलती थी कि हमको अब आपके पास रहना नहीं लेके गए और जो भी नहीं है उसके बारे में कुछ नहीं बट जो भी था ऐसा भी ये था तो एज ए गार्जियन एज ए पेरेंट उसको डांटते थे बस वो ये डिसाइड कर दी है नहीं No, ये postmortem report charge sheet has been submitted. Charge sheet has been submitted on just 3 months पूरा हुआ उसी दिन में ये 29/5/26
I have annexed counter affidavit.
29/5
अभी लिखे भी हैं
108 BNS में इनका चार्जशीट हुआ है डिपार्टमेंट ऑफ सोसाइटी में और विलेजर बोला है पारा 10 11 और 12 में बोले हैं कि ये लोग टॉर्चर करते थे ड्यू टू दिस विलेजर फूड के जैसे फाइट कर रहे थे
and one thing more that जब चार्जिंग सबमिट करने के समय इन्वेस्टिगेशन ऑफिसर ने से कि जुडिशियल कस्टडी जो है वो कम पूरा हो रहा है यानी अवधि इसलिए चार्जिंग करनी तो अभी भी अनुसंधान जारी है बाकी और 108 में otherwise nothing has कोई मार्केट में कोई कुछ नहीं पेरेंट्स भी इनको कहीं तो कुछ वो करना चाहिए था as per the fire itself, the victim was handed over to the family of the petitioner. Are the family members of the biological mother of the deceased, when she was 4 years of age. And after the death of the male member in the family where the victim was given, it is alleged that her brothers, it was alleged that she was being tortured by all the family members. The Land Council has further submitted that the biological parents never lodged any complaint in connection with any complaints. The victim, the charge sheet has been submitted under section 108 of BNS. The Land Council for the state has accused the player of bail and has referred to paragraph 10, 11 and 12 of the case diary and has submitted that the neighbors have specifically stated that the elder son of Nandu Devi
namely Ranveer Singh, used to abuse and assault the deceased, and immediately back in documents on 3/3/2026 at about 4 to 5 p.m. The petitioner was in a state of intoxication, and in the back lane of the house, he was abusing and assaulting the deceased, and after some time, the villagers had also come, which led to the committing of suicide of the deceased. After hearing the learned counsel of the parties and considering the evidence collected during investigation, this court is not inclined to announce the petition on their constitution.
After some time,
I can expedite your time. Custody
थोड़ा बढ़ जाता है फिर आपकी
आपका ट्रायल एक्सपीडिएट
यदि कोई एलिगेशन और है नहीं यानी मॉडल नहीं कोई कंप्लेंट भी करी नहीं है
Item 20, DA.5137 of 2026.
In this case, one of the co-accused, there has been listed on 17 days. DA number 5834 of 2026.
At the request of the council for the petitioner, tag this case with DA number 5834 of 26 and post on 77. उसके
हाँ काउंटर आ गया
उसकी केस डायरी हो
उसमें भी आ गया केस डायरी उसमें बहुत पहले ही हुआ था
केस डायरी आपके पास है
जी मिला गया
the council for the state has submitted the case diary.
Item 20N, DA.5141 of 2026.
Yes, you filed your document.
कल हम फाइल की
Yes.
Yes. You know, as per the FIR, it is page 11. She is stating that she is 18 years of age. You know, page 11.
ये सारे पीसेस सैटरडे इसके जहाँ जितने भी पैटर्न्स हैं सब सैटरडे को रहेंगे ऑलरेडी 3 केस है
इसमें सीरियल नंबर 22 और 23 इसमें काउंटर का ऑर्डर हुआ था हमने चेक किया लेकिन काउंटर इसके फाइल किया केस डायरी में नहीं
सैटरडे को रख हो सकता है इसमें चार्ज सैटरडे को रख
मंडे को रख
छुट्टी पर है सैटरडे कौन सा है
सीरियल नंबर 22 एंड 23 इसमें काउंटर के लिए हुआ था लास्ट ऑर्डर हुआ था
काउंटर नहीं आया है
काउंटर नहीं फाइल हुआ और केस डायरी के लिए हुआ केस डायरी की शायद आया है
सीरियल नंबर 30
कौन है कौन
स्टेट में सर एसके तिवारी
post this case on 27th.
Yes.
The counter affidavit should be filed latest by 23rd. Serial number 22 और 23 का दिया है।
24 से जो मेरा है मेरा एड्रेस क्लियर था 20 को रख दिया 30 में नहीं
30 में भी माइक
The same name of 31.
24, 30,
31
Monday.
At the request of the learned counsel for the petitioners, post this case on 20. बाकी सब आएगा तिवारी जी आप इसमें कुछ में दो केस में काउंटर नहीं कराएंगे 22-23 उसको हम रखते हैं 27 तारीख को 24 तारीख तक
29 में काउंटर रेडी है
29 the counter affidavit has been filed during court proceedings which is taken on the post on